Okay, good morning, everybody. Let's start our second day of the Trento Antitrust Conference. Yesterday has been recalled that this conference is becoming a tradition. Well, traditionally, the second day of the conference has been always devoted since the very beginning to the comparative approach, to the comparative analysis of experiences from other member states. So we are very keen and happy to have a very distinguished panel this morning. We have representatives from UK, from France, from Spain, Germany, Netherlands, and of course also Italy. Because it has been correctly recalled yesterday morning that public and private antitrust enforcement are part of the same enforcement system. Okay? Public and private is just one unique enforcement system. So we firmly believe, since the very beginning of this conference, that also EU-wide enforcement is part of a unique system. So what's happened in other member states is part of the same enforcement trend. And that this was true decades ago when we didn't have a common legal framework on competition litigation. You remember the famous BRT Sabam case? Where the Court of Justice said, okay, in absence of EU law, direct effect governs even procedural rules in competition litigation. This has been remarked also by Courage case, by Manfredi case, etc. So it's true, it was true decades ago. It's very, very true now, where we have a common legal framework across 28 jurisdictions. And if we have a common legal framework, some difference remains. Yesterday we studied the Italian experience. We focused very much on the Italian experience. Today we will see what is happening in other member states. But there are common features, there are common trends. We will discuss this morning about some key topics. For instance, standing. We will discuss about the passing on the fence. We will discuss about limitation period. We will discuss about disclosure, quantification of damages, and also we make some reference to another enforcement trend, a private enforcement trend, which is the very famous truck cartel litigation saga, which is taking place in several jurisdictions. So I think today we will have a lot of food for thoughts. Again, the idea is to have 20 minutes presentation in a way to have a more or less comprehensive presentation of what is happening in member states I mentioned, but also we will leave some room for the debate. So again, you are very much welcome for any question you have during and after this panel. Since the Italian experience has been explored in much detail yesterday, I will give the floor now to Professor Beniamino Caravita Itorito from La Sapienza University in Rome, who will talk us about a new angle of perspective. I mean, the perspective between constitutional law and public antitrust enforcement. It is a very typical situation that has been developed in Italy, but we think there are also some interesting reflections to export to our colleagues from other countries. So, Beniamino, please, the floor is for you. Thank you.
Grazie, io vi chiedo scusa, parlerò in italiano perché non ho fatto in tempo a preparare la relazione in inglese e farò riferimento specificamente ad alcune vicende italiane. Il diritto antitrust vive in questo momento, secondo me, una fase di grande interesse teorico e quindi inevitabilmente dalle gravi, importanti ricadute pratiche. Vi dicevo, vi parlerò fondamentalmente dell'Italia, ma credo, come anticipava Michele, che alcuni passaggi valgano mutatis mutandis per tutte le esperienze europee. Noi sappiamo, io personalmente l'ho sostenuto in varie occasioni, che oggi non ha più senso cercare il fondamento costituzionale della tutela della concorrenza nelle singole Costituzioni nazionali, ma il fondamento della concorrenza, la tutela della concorrenza, va trovato nell'articolo 3,3 del Trattato del funzionamento, del Trattato, scusatemi, sull'Unione Europea, laddove fa riferimento ad un'economia sociale di mercato fortemente competitiva. Non ripercorro adesso la vicenda dei mutamenti delle formulazioni, non è utile in questa fase. Sappiamo anche che il circuito delle autorità nazionali di regolazione, di quelle che noi chiamiamo autorità amministrative indipendenti, trova anch'esso la sua legittimazione non già all'interno degli ordinamenti nazionali, perché altrimenti si ripropone la tradizionale discussione sulla natura normativa, amministrativa, giurisdizionale di queste autorità, ma sappiamo che la legittimazione di queste autorità, non solo dell'autorità antitrust, ma di tutto il sistema delle reti delle autorità nazionali, è nel collegamento con la Commissione. Si crea, da un punto di vista di diritto costituzionale, una forma di governo peculiare in cui le istituzioni europee si servono delle istituzioni nazionali per applicare il diritto europeo. Io credo però che qualcosa stia succedendo anche sul buon funzionamento giuridico dei nostri meccanismi, che è sempre stata il motore del funzionamento dell'Unione, e che probabilmente è anche la conseguenza delle difficoltà che vengono vissute a livello politico dall'Unione Europea. Non vi nascondo che io sono rimasto molto colpito dalla sentenza del Tribunale di primo grado sulla vicenda del Fondo interbancario di tutela di depositi, e prenderò le mosse da questa sentenza perché mi serve ad aprire, a fare alcuni collegamenti con alcune vicende italiane e poi ricadere di nuovo sul private enforcement. La sentenza, voi lo sapete, ha annullato la decisione della Commissione, che aveva ritenuto che l'intervento del Fondo interbancario del Fondo interbancario di tutela dei depositi costituisse aiuto di Stato. Non ripercorro adesso la sentenza del Tribunale di primo grado, di nuovo sarebbe troppo lungo, mi limito ad osservare che il punto cruciale del Tribunale di primo grado è l'insufficiente motivazione, l'insufficienza di indizi, fondamentalmente il cattivo governo delle presunzioni. Il Tribunale ritiene, sotto una serie di profili, sotto il profilo dell'esistenza o meno del mandato pubblico, sotto il profilo dell'irrilevanza o meno della natura privata, sotto il profilo delle autorità, se le autorità pubbliche siano o meno in grado di influenzare l'attività del fondo, ritiene che la Commissione abbia malamente governato, non abbia saputo dimostrare l'esistenza di sufficienti indizi per sostenere la tesi degli aiuti di Stato. Mi si dirà, è un errore della Commissione, ha malamente governato le presunzioni, se fosse stata più attenta alla giurisprudenza pregressa non sarebbe caduta in questi errori. Beh, io penso che una logica di questo tipo significhi sottovalutare la portata di questa decisione. Di nuovo mi collegherò poi ad altri temi. Le presunzioni si governano male quando si sbaglia il bilanciamento degli interessi. Ciò che c'è dietro l'errore della Commissione non è un errore di malgoverno degli indizi, non è un errore di insufficiente dimostrazione degli argomenti, è un errore che nasce dal malgoverno del bilanciamento degli interessi. Se uno rilegge la sentenza di primo grado in filigrana, si rende conto che dietro quella sentenza c'è l'idea che non nasca, che non si possa chiudere la vicenda sulla presenza o meno degli aiuti di Stato e quindi sulla carattere di falsificazione della concorrenza, senza tener conto di tutti gli altri interessi che operano nella materia. Secondo me in questa sentenza c'è il Tribunale che dice: attenti a dove collocate il bilanciamento fra tutela della concorrenza e altri interessi. Passo all'Italia, perché anche in Italia abbiamo appena vissuto una contraddizione non dissimile, una contraddizione altrettanto grave, una contraddizione altrettanto riconducibile ad un sbagliato bilanciamento degli interessi. Faccio riferimento alla sentenza numero 13 del 2019 della Corte Costituzionale. Io la davo per conosciuta, ma non so se lo è a tutto l'uditorio, quindi qualche parola alla sentenza la dedico. La vicenda nasce da una ordinanza, la 1 del 2018, con cui l'autorità solleva questioni di legittimità costituzionale dinanzi alla Corte Costituzionale di una disposizione di legge che doveva applicare in un procedimento dinanzi a se stessa per presunta violazione degli articoli 41 e 117 della Costituzione, 117 primo comma della Costituzione, relativi in cui si ricava, in ambedue questi articoli, si ricava la tutela, il rango costituzionale nazionale di tutela della concorrenza. E fa ciò sul presupposto di poter operare quale giudice a quo, cioè quale autorità remittente, ai sensi dell'articolo 23 della legge 87 del 53 sulla Corte Costituzionale italiana. L'articolo 23 richiede che la questione possa essere sollevata se nasce da un giudice o se provenga nel corso di un giudizio. Si fa relativamente riferimento a un requisito di tipo soggettivo, la presenza del giudice, o a un requisito di tipo oggettivo, la presenza di un giudizio. Non entro anche qui nel dettaglio di una lunga giurisprudenza della Corte, di una risalente e faticosa giurisprudenza della Corte. Il punto fondamentale è che la Corte ha sempre ritenuto di dover integrare i due requisiti: soggettivo, presenza di un giudice incardinato nell'ordinamento giudiziario, corso di un giudizio, e quindi ha sempre ritenuto che non bastasse la presenza di un giudice, ma che occorresse l'applicazione di diritto oggettivo in una controversia delle parti, ma che non bastasse nemmeno l'applicazione di diritto oggettivo in una controversia alle parti, ma occorreva comunque che chi sollevava la questione fosse collocato in posizione di neutralità, terzietà e indipendenza fra le parti. Bene, la Corte, che pur poteva richiamare alcuni dei fondamenti costituzionali che ho citato prima, l'articolo 3 del trattato, il regolamento 1 del 2003, la direttiva uno del 2019 che stava per entrare in vigore in quei giorni, la Corte ha ritenuto che non ci fosse la legittimazione da parte dell'autorità garante della concorrenza. Vi segnalo che siamo di fronte ad un paradosso rispetto alle linee di tendenza della Corte Costituzionale negli ultimi anni, perché le linee di tendenza della Corte Costituzionale sono quelle dell'allargamento delle modalità di accesso alla Corte. Negli stessi giorni in cui dichiarava l'inammissibilità della questione proveniente dall'autorità, ha legittimato a sollevare conflitto di attribuzione i singoli parlamentari, ha confermato una giurisprudenza che ritiene che la Corte dei Conti in sede di controllo possa sollevare questioni di costituzionalità. Tradizionalmente la Corte ha ritenuto che si potesse adire il giudizio in Corte per la via di un giudizio di accertamento, sostanzialmente in mancanza di una lesione concreta e immediata delle situazioni soggettive. Aveva tradizionalmente fatto ricorso a una tesi, che è la tesi della possibilità di sollevare la questione di costituzionalità ai limitati fini, appunto, di adire la Corte. C'era tutta la riflessione sulla natura giurisdizionale o paragiurisdizionale di una serie di soggetti. Bene, la Corte ha tagliato la testa a tutti questi argomenti, non ne li ha tenuti in minimo conto, e con una sentenza andata forse addirittura al di là di quello che la Corte voleva dire, ma che oggi pesa nella discussione, con una sentenza molto drastica la Corte ha dichiarato inammissibile la questione proveniente dall'autorità antitrust. Avrebbe potuto farlo in maniera più blanda, avrebbe potuto, guardo qui Filippo, come dire, eravamo dalla stessa parte, perché io stavolta sì, altre volte per fortuna come avvocato mi capita di essere da una parte diversa, in questo caso eravamo dalla stessa parte, quindi sto parlando non adesivamente a questa prospettiva, ma sto parlando criticamente, sto parlando recependone i dubbi e recependo le conseguenze e tentando di pormi le conseguenze che questa statuizione della Corte può avere. La Corte non si è limitata a due parole, inammissibile, senza motivare, ma è andata giù, come si dice, è andata giù dura, ha contestato il requisito della terzietà dell'autorità antitrust, dell'autorità per la garanzia della concorrenza nel mercato. L'ha contestata non solo facendo riferimento al fatto che l'autorità, sulla base dell'articolo 21 bis, può essere parte nei giudizi, può anche ricorrere contro atti amministrativi dello Stato o degli enti locali lesivi della concorrenza. Era un argomento, la Corte l'ha utilizzato, ma non si è fermata a questo. La Corte ha contestato la terzietà, ha ritenuto non esistente la terzietà fra il Presidente e il Segretario Generale, e ha ritenuto che gli uffici dipendessero dal soggetto che decide, e quindi mancanza di terzietà fra chi agisce e chi decide, ma ancora più gravemente hai fatto delle valutazioni, come dire, in qualche modo ancora più incisive, ancora più gravi. Ha detto la GCM, al pari di tutte le amministrazioni, è portatrice di un interesse pubblico specifico, tutela della concorrenza del mercato, e quindi, qui sto citando, e quindi non è in posizione di indipendenza e terzietà rispetto agli interessi e alle posizioni soggettive che vengono in rilievo nello svolgimento della sua attività istituzionale. Al pari delle altre amministrazioni, portatore di un interesse specifico di cui non si assume, che si assume collocato allo stesso identico livello di tutti gli altri interessi pubblici. Questo deve far riflettere sul problema del bilanciamento degli interessi costituzionali, dei valori, dei principi che reggono le azioni amministrative. Ma non ha avuto nemmeno remora nel dire che il contraddittorio di fronte all'autorità non si differenzia da quello procedimentale classico, con la natura verticale del rapporto fra soggetti partecipanti e poi incisi e autorità, e con la mancanza di parità. Non si differenzia il procedimento dalle altre l'autorità non si differenzia, cito, forse non le parole testuali, ma abbastanza vicine, l'autorità non si differenzia dalle altre autorità pubbliche né per le funzioni, né per la posizione, né per la natura del procedimento. E il provvedimento è assimilabile a quello delle altre autorità amministrative. Una sentenza, diciamoci la verità, deflagrante. Una sentenza deflagrante. Da che cosa sia dipeso non entriamoci. Non andiamo a porci il problema del perché l'autorità abbia sollevato. Era un dibattito che in Italia era sempre stato presente. 25 anni fa io avevo ipotizzato che le autorità potessero essere parte dei conflitti di attribuzione fra poteri dello Stato. Qualche anno dopo, alla fine, o negli stessi anni, Giuliano Amato, come presidente dell'autorità, aveva ipotizzato la possibilità per le autorità di sollevare la questione, quindi c'è dietro una scia di riflessione, forse non è stata sollevata nel momento giusto, forse la Corte si è fatta prendere la mano, non ha ragionato sulle conseguenze, ma vi posso garantire che gli argomenti a favore sono stati portati tutti, fra cui anche gli argomenti su cui mi soffermerò fra un attimo, quelli di maggiore effetto dirompente sul sistema, li sono stati portati alla Corte e la Corte non ne ha tenuto conto. Perché non ne abbia tenuto conto non lo so, ma dobbiamo prendere le mosse da ciò. E allora la domanda è immediata. Rispetto a tutto il nostro dibattito sul private, non solo sul procedimento, c'è tutta la questione del procedimento, di come si deve svolgere, la lascio da un lato, ma è evidente che questa sentenza ha effetti fortissimi sull'organizzazione del procedimento di fronte all'autorità. Lascio da parte questo tema. E mi soffermo sul tema del private enforcement. Ma Michele, posso avere 2 minuti per concludere? Sì, perché ho visto che sono a 20, ma in 2 minuti cerco di concludere, poi eventualmente riprendo. E allora, di fronte a questa sentenza, come si giustifica più il carattere vincolante della decisione dell'antitrust nei procedimenti di private enforcement? Già in Italia c'era stato un lungo dibattito, e il dibattito era proprio sul punto se la decisione potesse fare effetto, sia rispetto alla decisione non impugnata si era sostenuto, e l'aveva sostenuto anche la relazione, che si poteva continuare ad applicare lo strumento della disapplicazione dell'atto amministrativo, quindi la possibilità per il giudice tipica dell'ordinamento italiano di disapplicare l'atto amministrativo. C'era stato un tentativo di ricostruzione che aveva aleggiato soprattutto in alcuni dibattiti con dei consiglieri, con degli autorevoli esponenti della Cassazione, circa il fatto che la natura di giudicato formale derivasse dalle sentenze di annullamento ma non dalle sentenze di rigetto, ragion per cui la sentenza del giudice amministrativo che confermava la decisione dell'autorità non avrebbe avuto giudicato formale. C'erano state tutte queste discussioni, ma qui riprende piede in pieno, riprende, come dire, forza in pieno la discussione di fondo. La discussione, cioè, se un provvedimento di un'autorità amministrativa possa vincolare un giudice. Discussione che nella vicenda italiana trova il suo fondamento costituzionale nell'articolo 101 della Costituzione, cioè della soggezione dei giudici solamente alla legge. Io ho fatto riferimento alla contraddizione più grossa, ma in realtà tutti gli aspetti, quelli del passing on, quella tutti gli altri aspetti ricadono in questa contraddizione. Rapidissimamente concludo. Noi siamo di fronte ad una possibile contraddizione, che è la stessa contraddizione che noi in Italia abbiamo avuto sulla cosiddetta saga Taricco, cioè la retroattività o meno delle norme in materia di prescrizione. Lì la Corte italiana ha eccepito che facesse parte dell'identità nazionale e dei principi fondamentali immodificabili e resistenti al diritto europeo la impossibilità della retroattività della prescrizione, e dopo una lunga vicenda che anche di nuovo non richiamo, si è trovata una composizione in cui la Corte di Giustizia ha dovuto almeno in parte accedere alle tesi italiane. La mia sensazione è che che probabilmente sul tema della tutela della concorrenza, per questo partivo dalla sentenza del Tribunale, si potrebbe aprire un conflitto fra le Corti Costituzionali nazionali sul tema tutela delle identità costituzionali, articolo 4, e la Corte di Giustizia come elaboratore e custode delle tradizioni costituzionali comuni, articolo 6 del Trattato. Una battuta operativa per chiudere: il problema è su queste vicende dove si va prima. Si andrà prima alla Corte Costituzionale, alle Corti Costituzionali, o si andrà prima alla Corte di Giustizia? Grazie.
Ti ringrazio molto Beniamino, questo interessante commento anche critico su questa sentenza, che in effetti apre uno scenario sistemico e sistematico, in un momento in cui peraltro ci apprestiamo nei prossimi mesi ad avviare il dibattito sul recepimento della direttiva VII Plus, che si colloca proprio sull'indipendenza delle autorità. Quindi abbiamo ritenuto utile fare un riferimento a questo, proprio perché ci sono anche prospettive anche comparatistiche e di impatto negli altri Stati membri. So now I switch again to English and we go deep in our comparative analysis of the experiences on private antitrust enforcement and competition litigation. I'm very honored to give the floor to Sir Peter Roth. Peter Roth is a judge of the Chancery Division of the High Court of England and Wales, and since November 2013 he is the president of the very famous CAT, the Competition Appeal, UK Competition Appeal Tribunal. Sir Roth, the floor is for you. UK. The second one.
Third, that's
That one.
yes. Can we make it bigger?
Good. Just right there.
No, that's one. Thank you.
Perfect.
Yeah.
It's full screen now.
Yeah, I'm going to use these. Thank you very much, Michele Carpagnano, and my thanks to the University of Trento for inviting me to speak at this important conference and to give me the opportunity for the first time to visit this beautiful city. And my thanks also to Giuseppe Conte for agreeing in the early hours of yesterday morning with the heads of government of the other 26 member states to extend the United Kingdom's departure from the European Union so that the UK does not leave this evening and I do not have to worry about getting a flight back to London. I thought it's appropriate to start by describing very briefly the legal architecture of competition enforcement in the UK, with an emphasis, of course, on private enforcement, as set out schematically in this slide. The CAT, the Competition Appeal Tribunal, as you've just heard, as its name suggests, was established originally as an appeal tribunal. That is, to hear appeals from the UK Competition Authority, at that time the Office of Fair Trading, now the Competition and Markets Authority, and also the various specialist regulators in telecoms and utilities and so on. It was then had its jurisdiction expanded to cover also private claims made by private parties at first instance. Those claims previously were brought in the ordinary civil courts, in England and Wales in the High Court, and in the equivalent courts in Scotland and Northern Ireland. As you may know, the United Kingdom comprises three different legal systems: England and Wales, secondly Scotland, and third Northern Ireland. So there was a parallel jurisdiction for private enforcement between the ordinary courts and the CAT. Then, with effect from the 1st of October 2015, a wholly new jurisdiction was introduced, that of collective or class actions in competition law, particularly to assist consumers and smaller businesses, and that jurisdiction was given exclusively to the CAT and exclusively in competition law. The CAT is unusual in that it is a tribunal, firstly, where we have a judge, but also, in any case, two of what we call the ordinary members, although there is nothing very ordinary about them. They are drawn from a pool of distinguished economists, people who worked in the public sector, and indeed also private lawyers. So it is an interdisciplinary tribunal, and the presence of economists, as you can imagine, is of great assistance when dealing with some of the difficult issues of quantification of damages. And secondly, it's unusual because it is a United Kingdom tribunal, whereas, as I've just explained, the ordinary courts will be either the courts of England and Wales, or the courts of Scotland, or the courts of Northern Ireland. But we have a pan-UK jurisdiction. So there is now, for private cases, a parallel track between the ordinary courts and the CAT. But in an important judgment in July last year, the Court of Appeal of England and Wales said that the special nature of competition cases is such that the High Court should, whenever possible, transfer a private claim in competition law started in the High Court to the CAT. And so the position now is that the CAT can hear, as it were, three types of private cases. First, cases that are started in the CAT Secondly, cases started in the High Court that are transferred to the CAT. And thirdly, the collective or class actions that I referred to. And then an appeal from the CAT can go, if it's an English case, to the Court of Appeal, if it's a Scottish case, to the Scottish equivalent Court of Appeal, if it's a Northern Irish case, to the Court of Appeal of Northern Ireland. And then at the very top of the structure is the United Kingdom Supreme Court, which is one of the few other United Kingdom courts with pan-UK jurisdiction. And as you see, the CAT or any of the other courts can make a reference to the Court of Justice. When we prepared this slide, I put a little red box around that because I wasn't sure if when I come to speak to you, we could still be making references to the Court of Justice, but it seems we can at least until the 31st of October. And indeed, there is a pending reference in a rather important case about pay for delay settlements from the CAT awaiting a hearing in Luxembourg. What is the position regarding private litigation generally in the UK? It is said for international cases that the UK, or more specifically England, is one of the favoured popular jurisdictions, along with Germany and the Netherlands. We can discuss later why that is. I don't think there are any actual figures, but that is fairly strong anecdotal evidence, and that is the case, although England is without question one of the most expensive jurisdictions in Europe in which to bring a case. And of course it was Britain that played a great contribution in furthering private enforcement of competition law because of that British institution, which perhaps many of you have had the opportunity of visiting. I refer, of course, to the English pub, and you will recall that in Courage and Crean, it was a beer tie on two English pubs operated by Mr. Crean outside Staines near Heathrow Airport, which prompted the reference to Luxembourg and the famous judgment stressing the importance of private enforcement and how, as the chairman just mentioned, private and public enforcement really promote the same objectives. What I can say is that we have now a significant number of private claims in England and Wales, far fewer in Scotland. Many of the damages cases so far have settled before judgment, though sometimes with some interesting procedural judgments on the way. We have had some, nonetheless, very large judgments. In one of the many cases brought against MasterCard, following on from the Commission and then the court in Luxembourg's decisions on the interchange fee, there have been some 40 cases brought in England by all sorts of suppliers of goods and services. Most are still awaiting the outcome of the lead cases, but a case brought by Sainsbury's, a very big British supermarket chain, against MasterCard resulted in a damages award of some £69 million. That is on appeal and now going on further appeal to the Supreme Court. And so all the other cases are waiting to see what the Supreme Court says. And in last October, a claim brought by a company called BritNed, which operates the interconnector for electricity between Britain and the Netherlands, brought a follow-on case after the Commission's decision in the submarine cables cartel. BritNed sued ABB, the big Swedish conglomerate, and in a very interesting and long, detailed judgment, recovered damages of 13 million euros plus interest. So there have been some big cases. We have some much smaller cases. There is pending before the CAT a claim by a lady who operates a bird sanctuary in the park belonging to a Benedictine abbey, and she is suing the monks of the Benedictine abbey for an alleged restriction of competition by abusing what is alleged to be a dominant position by refusing to allow her to open a cafeteria as part of her bird sanctuary. I can't say more about that case because it's coming for hearing later this year, but that is obviously at the smaller end of the spectrum, and there is a lot in between. An illustration of some of the complexities of these cases, it seems to me, is brought out vividly by the position we have in the trucks cases. As I'm sure you know, the the Commission in Brussels took two major decisions, finding that there had been a cartel between virtually all the major European manufacturers of medium and heavy trucks, operating for 14 years. It covered 90% of all medium and heavy trucks sold in the European Union over that 14 years. So just think about that in terms of private damages claims. Every business that bought or leased a medium or heavy truck over that period of 14 years, in principle, may have a claim for damages. So it is not surprising to read that there are now some 50 damages claims in various member states of the European Union and indeed beyond. I learnt recently there's one in the courts in Israel. I think there may be one in Turkey, but certainly there are in Germany, in the Netherlands, in Hungary. I believe there may be in Italy. In the UK, this was the position last week in terms of claims brought. Nothing has come to trial. And before I go on, I should say the main Commission decision, the decision of 2016, was a settlement decision with 5, I think, of the major truck groups, DAF, Daimler, Volvo, Renault, MAN, and Iveco, which I think is an Italian group. There was another major producer, Scania, which did not admit liability and did not settle. So the Commission proceeded in September 2017 to take a second decision, finding that Scania was a participant in the cartel. Scania has appealed that decision. Obviously, the others have not appealed because it was a settlement. So this is where we are at the moment in the UK. We have a claim by Royal Mail, delivering all the letters and parcels, think how many trucks they buy, against only DAF. British Telecom, only DAF. Ryder has sued DAF, Daimler, Iveco, and MAN, and Volvo. Suez, which is a big water distribution company, I think, and sewage, bringing together 339 claimants in its case, has sued 2 of the cartel companies, DAF and Iveco, but they, on the principle of joint and several liability, have brought in as a claim for contribution, so contribution defendants, MAN, Volvo, and also Scania. Veolia, 105 claimants, have sued 4 of the big manufacturing groups. They have brought in Scania as an additional defendant. Wolseley, there you have 153 claimants, and you see the position going down to Aula. That, as I say, was the position on Friday, when I sent over this slide. Friday afternoon, a further claim was lodged by a group called DS Smith, they have sued DAF, Volvo, Daimler, Iveco and MAN. And many more cases can still come because the limitation period in England and Wales is 6 years, and the settlement decision was 2016. One can discuss when does the 6 years start, but in any event, there's some time still to run. Then, in addition, we have 2 applications to bring a class action or collective action, one by a special purpose vehicle, UK Trucks Company, UKTC. They want a collective action on an opt-out basis for, they say, some 600,000 or more trucks. And an alternative or additional application for a collective proceedings is brought by the Road Haulage Association, the trade association of all the road delivery companies, the RHA, that they say should be an opt-in collective action for 6,400 claimants. The collective action proceedings is a special regime. There isn't time to describe it in detail, but basically the court, the CAT that is, has to certify and grant approval to an application to bring a class action to be satisfied it's an appropriate case for the criteria for a class action. So these are applications to bring a collective proceedings, and those applications will be heard by the CAT at the beginning of June. So we have different defendants to the different claims and different additional parties, and they therefore raise many of the complex issues that can arise on private enforcement. And as you can imagine, each of these defendants is very well funded. They engage very large law firms, no expense is spared, and they take every legal point you could possibly think of, and several that I suspect you could not think of. So there are legal issues, and there are the practical problems of just managing these cases. And I've tried to set out what are some of the matters that we are now grappling with. And they go to the heart of some of the issues that we are all here discussing. First of all, how does one manage all these cases with these different complexities of parties? We have confidentiality rings for business secrets to be disclosed only to the lawyers and the economic experts. But should it be one confidentiality ring for all the cases, although there are different, or should there be different confidentiality rings and overlapping rings? Translations. This was an international cartel. Many of the documents are in Swedish, German, French, Italian. The claimants need working copies and are getting them translated. Should one have some system for sharing translations to avoid wasted cost? On the other hand, the parties are very sensitive about disclosing which documents they've decided to have translated, because that might disclose the way they're planning their strategic thinking. There are the claims against Scania that you saw on the previous slide. What do we do about that? Scania has appealed, so those claims cannot be heard, of course, until the appeals are decided. So do we hold up all the other cases to await what could be several years of appeals before Luxembourg? Can they go ahead without Scania? What should one do? Disclosure. In this case, as in others, there is the problem of the Commission decisions not being published in full, or indeed with Scania still not published at all. The Scania decision was a decision of September 2017. Here we are in April 2019, still no available copy of the decision. Everybody wants to see that decision because, as the first trucks decision is a settlement decision, it's fairly brief and doesn't give much detail of the cartel. The Scania decision, being an full infringement decision, will be much more detailed and will be very useful. The process for the Commission to produce even what they now call a provisional non-confidential copy is very extended, and any decision they take can be challenged before the hearing officer of the Commission. Any decision that he comes to, I think they're both he at the moment, can be challenged before the General Court. All the claimants are asking for documents from the Commission file, which the defendants have. Should they be ordered to give the whole file, apart from leniency documents, which of course are excluded, or should it, on the principle of proportionality and all the strictures in the damages directive about disclosure, should it be only part of the file? And then, well, what is a leniency document? We are now having an argument as to whether everything that a settling party sent to the Commission that is not an original contemporaneous document, does it count as a leniency document, or should that be interpreted more narrowly? And then, of course, there is the horrendous business of disclosure more generally. Disclosure is something that, of course, the English courts have dealt with for decades. I think the United Kingdom and Ireland are the two member states with the greatest experience in disclosure. But the scale of potential disclosure, when you have a 14-year cartel, when the economists trying to produce an estimate of the overcharge employ a technique, one of among several techniques of doing, sometimes they do a before and after. This cartel is so long it might have to be during and after, but it means they're looking at prices during the cartel period and prices when there was no cartel. So it's not just the 14 years, it's several years thereafter as well. And the sort of data that they want is boundless. And yet one is trying to keep it reasonable and proportionate. Next, the binding nature of recitals. What do I mean by that? What I mean is that we have the Commission decisions, one we've seen, one we haven't seen. The operative part of the decision, what the French call the dispositif, is clearly binding. They've settled, there was a cartel, they did infringe Article 101. It was a cartel by object, not by effect. But what about all the recital paragraphs leading up to the operative part? Well, the EU law, as I'm sure you know, is that only recitals which constitute an essential basis for the operative part are binding on the national courts. Well, that's fine when you say that in the abstract, but you then get several hundred recitals and the claimant saying, well, these are all the essential basis of the operative part, and the defendant saying, no, it's only recital 184 and recital 226, and everything else is not the essential basis. And the court is left, the national court, having to try and decide that. And that could be extremely important, as you can imagine, to the evidential nature of the trial. Liability of non-addressees. This was a cartel at I think some of the German subsidiaries may have been involved, but it was basically at parent company level. It was a very high-level series of agreements. Quite shocking for that, and that's reflected in the fines. But the claimants didn't buy their trucks from the parent company. They bought their trucks from the various national subsidiaries. Are the national subsidiaries liable as defendants for damages for that breach of Article 101? Does one apply the EU concept of the economic entity, or should national law take a different approach? applicable law. In Suez, if we can go back, can I do that? Yes. Suez, 339 claimants. Those claimants are companies in the UK, Belgium, the Czech Republic, France, Germany, Luxembourg, Poland, the Netherlands, Spain, and Sweden. So they will have bought their trucks in those countries. In Wolseley, 153 claimants. We have not only the UK, of course, Austria, France, Germany, Ireland, Netherlands, Sweden, and Switzerland, but also a claimant in Kazakhstan and a claimant in Russia. What law governs their claim for damages? If they bought their truck in Russia, or even if they bought it in Poland, is it the law of the contract? Is it the law of etc.? You can see the scope for interesting legal argument. And finally, pass on. Pass on is a huge issue in the trucks cases, probably one of the most important issues. The claimants are all direct purchasers of the trucks, and they're all trading entities, they're all businesses. Some of them are themselves engaged in leasing trucks to their customers. If they paid, as a result of the cartel, a higher price for trucks, which is of course denied by the defendants, by the way, and it was a cartel by object, remember, not by effect. If they paid a higher price, and that's shown, might the businesses paying that higher price have paid themselves, have charged their own customers a higher price for goods and services, such that under the principle of the pass-on defence, it's sometimes called, so-called defence, it's not really a defence, it's really what is the measure of compensation. Do they have to give credit? How far must one go? Is there a difference between a company which bought trucks to rent them out, so its business was renting out trucks, and a company like, say, the Royal Mail, where can DAF say, but the price you charge for postage stamps may reflect the extra price you paid in purchasing your trucks, and so we can look at what happened to the price of postage stamps, and you have to give credit for that as a potential pass-through. And we are, without question, going to face these issues. But it's not just that we face these issues. Clearly, we want to have on these overall issues a common position, a common legal result, as across all these cases. And how does a court manage the process of getting a common answer when you have different parties to the different cases before it? So that normally, of course, decision in one case between one set of parties doesn't, under ordinary established principles of res judicata, would not bind other parties. So that, I hope, gives you something in a snapshot of the flavour of how complex private enforcement can become. The legal position, essentially in the UK, I should conclude perhaps by saying, is that although the EU Damages Directive has been implemented and the disclosure provisions in the Damages Directive have immediate effect, the rest of the directive pass through the presumption of harm, joint and several liability provisions and limitation, apply only in the UK when the damage occurred after March 2017, which was the date of implementation. So none of the other provisions of the Damages Directive have any bearing in the trucks cases, only the disclosure provisions. And that is probably the point at which I think I can end. I'm happy, of course, I hope, some time for discussion to talk about some of the other issues, and the way we approach quantification of damages in the UK, the way we use expert evidence, all I will say in conclusion is that the English practice in competition cases, as indeed in other cases with expert evidence, is that the court does not appoint an expert. I know in Italy that is the approach generally, that the court will appoint an expert. In Wales and in Scotland, we don't. The parties appoint their own experts, and the court will hear both experts give evidence being cross-examined, and then will decide and reach its own view. Thank you very much.
Thank you. Thank you very much. Thank you very much, Peter, for this very useful presentation that shows once again how common are the problems relating to the application of competition law across EU, and the truck cartel case is a clear example that we are all on the same page on this, and we have to learn on different experiences from different jurisdictions. Apparently, France is one of the few jurisdictions in Europe where there is at the moment no truck litigation. So I will give the floor now to Romain Moulin, who is substituting today Mrs. Muriel Chagny, who is, unfortunately is not able to attend the conference. Romain is a private litigator. He's one of the experts on private enforcement in France. So Romain, the floor is for you. Please tell something more about the experience of private litigation in France.
Well, thank you. Thank you, everyone. Sorry for not being able to express myself in Italian. You'll have to stand with my English. First of all, I'd like to give you some preliminary background on the way the private litigation worked in France. Because it's true that there is a belief that private enforcement litigation in France is a bit underdeveloped. And to some extent, this belief was strengthened by the French competition authority itself, which put the emphasis on public enforcement rather private enforcement, basically by saying we are very happy with private enforcement developing, but we don't want it to jeopardize our public enforcement mechanism and initiatives. We do have in France a class action type mechanism, which was introduced in 2014, which, contrary to the EC recommendation on that topic, only cover follow-on actions. The only entities which are able to bring that kind of action are what we call approved consumer association. They are 15 at the moment, and this list is exhaustive. One of the most famous or one of the most active is UFC Que Choisir, which you may know. Lawyers themselves are not able to bring collective action on behalf of consumer, unlike what happened in the US, for instance. And this is an opt-in regime. If you want some figures, to date we only have 11 cases which were brought, and mainly on the ground of unfair commercial practices. What we call pratiques commerciales trompeuses in France. So nothing to do with competition law. Now, if we go to private enforcement litigation, the directive, the 2014 directive, was implemented into French law through an ordinance and a decree, which were taken in March 2015, like in the UK, right at the same time than the UK. And it is true that within this time frame, there have been several major rulings which were ended on mainly by the Paris Commercial Court and by the Paris Court of Appeal, which has, and I think it's something which is very relevant, a specialized chamber with renowned judges and also the help of economists, just like Peter Roth said, to strengthen their reasoning on this point. Another initiative I wanted to mention is the fact that the Ministry of Justice took in March 2017 a soft law guidance to better explain to plaintiffs and their legal advisor as well, and I found this document very useful, the exact scope and meaning of some of the provisions of the directive itself, but also of the French implementing measures. And the last initiative I wanted to mention is the fact that the Paris Court of Appeal, end of 2017, issued a soft law guidance, which they call fiche méthodologique, specifically on the quantification of harm, which is a very important issue in France as well. So here again, if I were to provide figures, I'd say that there are around 60 cases, or there have been, or there are currently 60 cases of private enforcement in France, most of them being follow-on litigation in the context of hardcore cartels. 13 cases being abuse of dominant position cases, which were initiated as a follow-on action, meaning after an infringement decision, either from the European Commission or the French Competition Authority, and 18, which is quite a lot, 18 were brought in the context of abuse of dominant position, which were initiated as a standalone action. Okay? And I can mention the fact that since they are here, cartel damage claim never lodge a private action litigation in France yet. If we focus now on the issue of direct and indirect purchaser, we have an issue in France because Article 4815 of the French Commercial Code, because the directive was implemented mainly into the French Commercial Code, says that the direct or indirect purchaser, be it of goods or services, claiming that to have suffered from overcharges or their passing on, shall prove their existence and extent. So, how do we construe that in practice? Basically, for direct purchaser, unless the defendant can prove the contrary, there is a presumption that they have not passed on the overcharge on their customer. For indirect purchaser, there is a rebuttable presumption that they incurred an overcharge which was passed on by their supplier. So I put a table. Sorry, it's not a good sign. So I put in my table, my slide, a table to show the contradiction between these two provisions. And to date, I have to say that we have no decision from French courts giving, an interpretation of these provisions, and we have no French court precedents awarding damages to an indirect purchaser. So that's an issue that we have to litigate. Now, if we move on to the passing on defense, we've had before the directive, we had many cases on passing on defense, and I think the French Cour de Cassation made an important ruling in the context of the lysine or vitamin cartel, where the French Cour de Cassation considered that the passing on defense could be an argument that a defendant can use in defense. Now, through the implementation of the directive, of the 2014-14 directive, Article 4814 of the French Commercial Code takes the opposite view, since it brings a rebuttable presumption against pass-on overcharge. And it is true that a defendant may rebut the presumption by adducing evidence of passing on overcharge, even partially, and that's important, even partially to end customers. This requires, of course, economic analysis, and we go back to that after in my presentation. And on the basis of this, of course, a judge may reduce damages in proportion of the portion of passed on overcharges, which is a very difficult assessment, especially for first instance jurisdiction, which do not have the expertise for that kind of litigation. Important issue is also quantification of damages and interest. In France, and I think it's the same in Italy, at least, there is this principle of full compensation. There also is this idea that the compensation that the plaintiff is entitled to should be assessed only on the basis of the damage he suffered, and not, or at least not only, on the basis of the gravity of the wrongdoing committed by the infringer. So we are not like in criminal proceedings, and I think this is something we all have to keep in mind. The French legislature took the position to introduce into the French commercial code an exhaustive list, a non-exhaustive list of the type of damages which are which can be claimed by a plaintiff. And they use the verb notably, which would translate as notamment in French, and they list the different type of damages, which are mainly direct losses, then lost profits, the loss of opportunity, what we call perte de chance in French, and moral harm, and this will have to be defined in future litigation. One point that I wanted to mention is the fact that the French Commercial Code does not refer to the notion of umbrella damages, which you all know since the Cornet ruling from the European Court of Justice. And I think it's not an issue because I think by the effect of this ruling and by the effect of the primacy of EU law, French litigants or French victims will be able to seek compensation for this type of harm as well. One issue that I wanted to mention also is the notion of the effects of time on the quantification of harm. And Peter Roth rightly said that cartel produce effects on a very long period of time, and also that private action litigation can take time, and as lawyers we take any opportunity to slow the process as we can, when we have to, or to speed up the process when we try to. But still, between the moment the damage occurred and the moment the judge will give his decision, they can be many years. So how do we take that into account? And here I wanted to point a provision of the French Commercial Code which clearly says that the damages shall be assessed at the time of the ruling, which makes sense, taking into account all circumstances that may have affected the consistency and value of the damage since the date occurred. It's very important to keep that in mind, because it can, in some cases, you can have a main or a theoretical damage which could be, let's say, 10 million, and when you take the effect of time, you can enhance the quantum by 30%, for instance. So I think it's important. Still on the quantification of damages, there is a presumption of causality, which is clear in the French Commercial Code, but the scope of this presumption is limited to the existence of damages, which means that plaintiffs are still required to prove the amount that they actually suffered, the quantum. And here I have to say that the French implementing measures did not strictly follow the wording of the directive by empowering judges, national judges, to provide their, let's say, their own assessment of the damage when it's impossible for a plaintiff, for any reason, to come up with a robust figure. However, I think we can circumvent this difficulty since French law and French judges already are used to have some discretion in the way they quantify damage and in the way they come up with a figure. And also, I think it's important to note that national judges in France used the 2013 practical guide from the European Commission on the quantification of harm, and also the very recent fiche méthodologique, which I mentioned in my earlier slide, which are dated 2017. They used these two soft law guidance as a useful guide, for coming with the right figure. Now, the issue of disclosure, and I'm a bit, confused because talking about disclosure after Peter Ross is a bit difficult because in France the system is a bit different. So you all know that the implementing measures, just as the directive, are trying to reduce the hurdles for plaintiff in getting the right evidence or the incriminating evidence. And it is true that in France, we already had some mechanism which applied in the context of other type of litigation, mainly liability litigation. And the purpose of the implementing measures in that respect were to fine-tune these provisions to make sure that they will apply in a relevant way to private enforcement litigation. And now, in France, a plaintiff can seek the disclosure of any type of evidence, and in particular, this notion of categories of evidence, which you know because it's from the directive itself. This will only be done by the French judge following a proportionality test and a balancing of interest. And it is true that in that regard, the protection of business secrets can be used by the defendants to slow the process or to reduce the scope of disclosure. And the French legislator took that into account and introduced the possibility of discussing this type of evidence when they contain already the business secret, to discuss them in camera, what we call huis clos in France, or to limit access to certain portion of elements which we consider useful for the claimant. And here I wanted to mention the fact that if the defendant, which is required to produce or to disclose an evidence to the plaintiff, does not comply with this order, the judge can impose a daily penalty, an astreinte, or if the defendant continues to not to comply with the order, to fine this company up to 10,000 euros. And here, I'm playing the devil's advocate here, but I'm wondering what is the deterrent effect for a company which is being sued for, let's say, millions euros in a context of a private litigation. What is the deterrent effect of a procedural fine which is limited to 10,000 euros? We all have the answer. Now, I wanted to, if I have time for this, I have time, so I'll
3 minutes more.
oh, nice. It's more than enough. I have, 4 cases I wanted to mention to you. 3 of them are follow-on cases, either from following the Commission decision or the French Competition Authority. And the last one is a stand-alone case. So first of all, BetClick PMU. In this case, and you have, the background here, so I will go quickly to keep the time. 3 main issues here. Is a mere commitment decision sufficient for the purpose of a private action litigation? Here, the Paris Court of Appeal found that it is true that this type of decision does not contain a finding of infringement in itself. However, it contains background elements and evidence which can be sufficient to hold the defendant liable in the context of a private litigation. And here, it was quite interesting because PMU, which was fined by the competition authority for an abuse of dominant position, said basically, with some bad face, that it didn't do anything wrong because and that its practice could not have a foreclosure effect for new entrants such as BetClick. Because the French Competition Authority decided to close the case through a commitment procedure. The Paris Court of Appeal was not convinced by this argument. In terms of quantification of harm here, it's and I think it's very interesting what Peter Roth said, that in the UK the court will not hire an independent expert or a court expert, what we call an expert judiciaire in France, because here both parties were hiring their own legal expert, and on the basis of the elements that they gave to their respective economists, these 2 economists reached very different conclusion. So the Paris Court of Appeal had no choice but to appoint an expert to try to find a workable quantification of harm. Also, something which I found very interesting, and to me was the first time that someone tried that in court. BetClick, since they know that the litigation will be very long, asked for the judge to grant them a financial provision to recover part of their damage, and also to make the necessary investment to develop on the market, because they were saying basically that PMU, prevent them from entering in an efficient manner on the market. And here the courts considered the request, which is a good sign, but found that since BetClick was not willing to disclose its financial accounts and its financial figures, the court was not in the position to assess whether this provision was necessary. So the claim was rejected. Maybe I can talk about this last case. You have the other 2, which you can read by your own, and if you have any question, you can send me an email. I'll be happy to answer it. Here in Doualiment, the issue was the starting point of the limitation periods, which in France is 5 years. I think it's the same in Italy. And what's very interesting here is that in first instance, the plaintiff was dismissed as time-barred because the Quimper Commercial Court, I don't know if you know Quimper, but it's a very small jurisdiction, considered that the starting point was the date when the European Commission initiated proceedings against cartel members, including TMAB Industrie. And the Paris Court of Appeal annulled the ruling on this ground by saying that the only starting point is the publication of the decision, the infringement decision. And it is true that it can take some time between the time that there is a press release from the European Commission or for any other national competition authority, and that the provisionally or the full non-confidential version of the infringement decision is published. But still, the starting point is a press release from the National Competition Authority saying we did fine this company for this type of infringement. Okay. And here also the issue on quantification of harm. The court said something very important, which is that the appointment of an independent expert can only be accepted when the plaintiff brought sufficient evidence for the harm that he allegedly suffered. And it is true that in this very case, Doualiment was not in a position to quantify in a robust way the harm suffered from the cartel, especially since TMAB Industrie was contending for the first time before the Quimper Commercial Court, which is not an expert in competition law. So TMAB Industrie was contending that it played the role of a maverick in the context of the cartel. So Doualiment, as a plaintiff, requested the appointment of an expert, and the court found that in this very case, the only person that would be able to come up with a figure would be an independent expert. So they hired one. Okay. Do I have time for one more or?
1 more minute.
1 more minute. No. No, I think it's very interesting because what we heard about the fact that in the UK you are not very familiar with the appointing an independent expert, and I think this is very important, and it is on my last slide, so you can have a look at them. Hiring an independent expert to come up with a figure can only work if both the plaintiff and the defendant play the game and provide the figures and all the elements that they have. And it is true that they don't have the same interest. So I expect that in these two cases, the independent expert, who is an economist or an auditor, will have trouble in finding the right figure. And I'm pretty sure that his assessment will be in any way strongly challenged on appeal. So that's my last word.
Thank you very much, Roman. Is there any question from the audience before the break? 1, 2, and 3, 4. Okay, I can count until 6, no more. Ok, sì, grazie. Giudice Simeoli, il microfono mobile non ce l'ho. Lo stanno portando. Eccolo là. I mean, the question could be made both in English and Italian. Don't worry about that.
Salve, Simeoli, Consiglio di Stato. Volevo tornare sulla questione della legittimazione dell'autorità garante sulla sentenza della Corte. Ma c'è un passaggio che forse non ho compreso l'intervento, nel senso che la Corte Costituzionale non ha mai riconosciuto la legittimazione a sollevare una questione incidentale di costituzionalità a una pubblica amministrazione. È vero che negli ultimi anni c'è stato un ampliamento della legittimazione sotto il profilo della fictiolitis, dell'azione di accertamento, oppure nel caso della Corte dei Conti, Però in entrambi i casi si trattava di un soggetto posto in posizione, almeno istituzionale, di giudice, mentre l'autorità si pone all'interno del processo sanzionatorio come soggetto che applica la sanzione, quindi non è configurabile un contenzioso nel quale l'autorità garante si pone come soggetto che applica le norme per dirimere una controversia. È vero che nel caso della Corte dei Conti forse quello è il caso un po' più vicino, perché lì la Corte nel caso del giudizio di parificazione è stato abilitato recentemente a sollevare una questione non solo per il parametro 81 ma anche per tutti gli altri parametri. Però lì la Corte valorizza la posizione di giudice magistratuale della Corte dei Conti, le forme di rito giurisdizionale del giudizio di parificazione. Forse lì c'è un allargamento, però comunque non si tratta appunto di un procedimento più vicino a quello giurisdizionale, non si tratta di una pubblica amministrazione che applica una norma e non dirime una controversia. Quindi ecco, quel passaggio lì forse mi è meno chiaro. E poi invece sulla questione del vincolo di accertamento del provvedimento, ecco, mi interessava ritornare sulla questione di costituzionalità, perché effettivamente esistono provvedimenti che hanno un effetto di accertamento, però per la prima volta questo effetto di accertamento si impone al giudice, e per la prima volta al giudice è precluso sia di trarre dalla disposizione della norma, cioè la qualificazione del fatto, sia di applicare questa norma al fatto che accerta. Voglio chiedere se secondo lei faceva una prognosi, diciamo, di possibile fondatezza della questione sull'articolo 101, no? Mi pare di capire, della Costituzione, perché effettivamente lì si pone il problema del giudice che applica soltanto, il giudice è soggetto soltanto alla legge, e di solito i costituzionalisti hanno ritenuto che questo soltanto volesse indicare che questa soggezione è come dire, un presidio dell'imparzialità del giudice, questo suo rapporto diretto con la norma è un presidio di imparzialità. Voglio dire se per caso secondo lei la Corte potrebbe porsi il problema della natura assoluta di questa prescrizione costituzionale, cioè non bilanciabile con gli altri valori che in questo caso dovrebbero derivare dalla partecipazione dell'Italia a quella rete giurisdizionale di cui lei aveva parlato all'inizio dell'intervento. Grazie.
Vuoi rispondere subito, poi prendiamo le altre domande? Per cortesia, però una risposta flash.
Brevissimo. No, non avevo ancora fatto prognosi, ponevo il problema del 101, che è il parametro di una vicenda di questo tipo. Si potrebbe lavorare sulla natura assoluta o meno del vincolo, ma questo ci metterebbe in contraddizione con la direttiva e quindi si apre il problema del rapporto con la posizione della Corte di Giustizia. Sì, è vero, però c'è stata tanta riflessione teorica sul problema di attività di tipo paragiurisdizionale, se potessero sollevare la questione di legittimità costituzionale, e c'era stata quella giurisprudenza che dice che un'autorità, un soggetto può essere ritenuto autorità giudiziaria tale da sollevare la questione ai soli limitati fini della sollevazione, ed era stato utilizzato per arbitri, per CSM e per Corte dei Conti in sede di controllo. Su questo facevano leva quelli che pensavano che si potesse sollevare. Niente, mi pare per limitarmi. Grazie. Mi fermo qua.
Un'altra domanda credo lì su c'era. Ecco.
I'm Giovanni Scoccini, my lawyer. I have a question for both Sir Roth and Maureen. Is about contribution defendants. As far as I understand, the English system allow the main defendants to call the contribution defendants in the main proceeding. My question is, if the English judge has the power to deny the call from the main defendants of the of the contribution defendants, and as for Mr. Maulin, if in the French system the main defendants can call in the main proceeding the contribution defendants.
The short answer is yes. Technically, the contribution claim is a separate claim. So plaintiff or claimants use the defendants. The defendants start contribution proceedings against other parties who are not already in the action, or indeed against parties who are already defendants in the action. And then it is a question whether that contribution claim should be heard together with the main claim or afterwards. And you won't be surprised to hear that is one of the issues that we have to deal with in the trucks case, because the defendants are saying we want our contribution claim to be heard with the main claim, and the claimants are saying no, this will complicate and extend the trial of our claim, and we do not want it heard together with the main claim. That is one of the many issues we are going to have to decide. In simple litigation, it's often convenient to hear the two claims in one trial for reasons that I think are obvious. Whether that's so in this case, we'll see.
And to answer your query, in France as well, we have the system of contribution defendant where you can ask for another defendant to join. And I think it's in their interest for cartel members. They have sometimes they have a joint defense group, either before the competition authority and in the private enforcement litigation. It's important that they all tell the same story. And in any way, there is this principle of joint and several liability. So when you are exposed as a defendant to the payment of damages, you better be on trial to make sure that your points will be made. So it's possible in France as well.
Can I add one thing?
Yeah.
I mean, the point of your question, which is a very good question, is particularly acute in the trucks cases, because if you remember that table, none of the claimants have sued Scania. Scania is brought in as an additional defendant. If that has to be heard together with the main claim, I don't see realistically how you could have a trial until after the Scania appeals in Luxembourg have been determined in 2, 3, 4 years' time. The court is then in, where are we? In 2023, having to look at the effects of a cartel in 1997. So the claimants are quite keen in that case to say that the additional contribution claim should not be heard at the same time, because they want to get on and recover their money. And you can see where the interests of the defendants might be.
Thank you very much. We are 22 minutes late on schedule, so I think it's better to have a coffee, and we come back in 10-15 minutes for the second part of this panel. Thank you very much. Okay, so we can start the second part of this first panel of the morning. We continue our comparative analysis of the experiences of competition litigation across Europe. Now it's time to see what is happening in Spain. We are honored to have the judge of the Audiencia Provincial of Valencia, Eduardo Pastor Martinez. He will deliver us his speech in Spanish. There is a translation in any case. His lot of experience on litigation in court, in juzgados de lo mercantil. So, Eduardo, the floor is for you. Thank you very much.
Thank you. Miguel de Cervantes, lo spagnolo più universale, ha scritto che colui che legge molto e cammina molto vede molte cose e sa molte cose. Voglio iniziare questo breve intervento ringraziando l'Università di Trento e gli organizzatori del congresso per avermi dato l'opportunità di essere qui oggi con tutti voi. Devo anche ringraziare Michele per la sua gentile presentazione. Se confronto la mia carriera professionale con quella di molti di voi, Mi rendo conto di essere stato invitato a partecipare oggi perché rappresento il momento spagnolo nell'applicazione privata della legge sulla concorrenza. Siamo giovani, abbiamo poca esperienza in questo campo e sarebbe disonesto affermare il contrario. Tuttavia, siamo nella posizione migliore per leggere e camminare molto, vedere molte cose e sapere molte cose. In questi giorni, insieme a voi, i vostri contributi e riflessioni costituiscono un magnifico bagaglio che arricchirà la pratica professionale dei giudici spagnoli. Grazie. Well,
I'm quite familiar with Spanish, but this looks like Italian, no?
Una fratella politica, Fiorentina. Okay, my intervention will briefly address 5 major issues. I speak an abstract in English and later I will use the Spanish. First, a brief description of the Spanish jurisdiction, our process and its recent position in follow-on actions. Second, an allusion to our leading cases by the Supreme Court and also by commercial courts as a starting point for the transposition of the directive. Third, my opinion about the identification of the indirect buyer, who is, and what about passing on defense. Later, I will talk about the context and development of our disclosure, and at least a few points about the calculating damages. 20 minutes, maybe. Creo que ya he usado unos cuantos. Italian, English, I'm sorry, now Spanish. Muchísimas gracias a todos. Bueno, pues en primer lugar, para hablar sobre la jurisdicción española, y Gabriela, la traductora, me ha dicho que hable despacio. No tenemos una gran experiencia en la aplicación privada del derecho de la competencia. Y no podemos afirmar lo contrario los jueces españoles. Sin embargo, eso no quiere decir que no seamos una jurisdicción confiable y que esté preparada para aceptar el desafío de la aplicación de este nuevo derecho. Que no tengamos una gran experiencia no quiere decir que los jueces españoles no estemos especializados en derecho de la competencia. Al menos estamos relativamente especializados para el conocimiento de este tipo de materias. Desde el año 2004, en España existe un doble circuito de enjuiciamiento civil. Una jurisdicción civil ordinaria y unos juzgados especializados en el ámbito mercantil, servidos por aproximadamente 100 jueces en toda España, en distintos niveles de enjuiciamiento, que resuelven procesos específicos en materia de derecho de la insolvencia, derecho societario, propiedad industrial y aplicación privada del derecho de la competencia. Es cierto que de todas estas patas, pues la más frágil es la del derecho de la competencia, porque no hemos tenido grandes casos. Pero sí que hemos predispuesto, se ha construido en España desde el año 2004 un cauce específico para cuando llegara este momento de aplicación de un derecho nuevo. Además de eso, en España tenemos 2 niveles de juicio, de enjuiciamiento ordinario y un tercer nivel ante el Tribunal Supremo. Un primer nivel que está servido por jueces más o menos con mi trayectoria profesional, un poco más de experiencia que yo, más años de trabajo que yo, audiencia provincial, jueces ya en su madurez profesional, y el tercer nivel extraordinario, el Tribunal Supremo. ¿Es suficiente este nivel de especialización de los jueces españoles para aplicar el derecho, la aplicación privada del derecho de la competencia? Bueno, seguramente en el futuro haya que seguir dando pasos para construir órganos especializados, pero en cualquier caso es una estructura que se adapta bien a las necesidades actuales de la litigación en España. ¿Por qué? Pues porque, de acuerdo con las particularidades de España en general, donde todo es pequeño y fragmentado, tenemos ya cientos de casos en aplicación privada del derecho de la competencia. Y el hecho de que no tengamos un solo tribunal, sino que tengamos distintos jueces operando en paralelo en distintos puntos del país, de momento nos permite absorber esta litigación. Y prueba de ello es que si tenemos mucho en lo que mejorar y tenemos mucho todavía que aprender, lo cierto es que, yéndonos al caso paradigmático de los camiones ahora mismo, España ya ha resuelto en 9 casos 9 acciones de enjuiciamiento de acción privada de daños derivada del cártel de camiones, desde el principio hasta el final en la primera instancia. Luego serán revisados esos pronunciamientos en la segunda instancia, pero estos casos ya han sido resueltos. Cuando el magistrado Roth identificaba las cuestiones de derecho discutidas en este tipo de procesos, en este caso en concreto, los jueces españoles ya han tomado una posición sobre todas esas cuestiones. Será confirmada o no será confirmada en la segunda instancia, pero lo importante es que esos pronunciamientos ya son susceptibles de ejecución provisional de acuerdo con nuestro sistema de enjuiciamiento, donde no hay una separación entre la liability y la quantification, es todo en el mismo juicio. Por lo tanto, en España partimos con la desventaja de la falta de experiencia, es cierto. Quizás precisáramos de una especialización mayor, y luego hablaremos de algunos aspectos particulares sobre eso, pero bueno, también creo que podemos presumir de algunas pequeñas cosas. La primera, nuestra predisposición para seguir creciendo, y la segunda, el hecho de que, al menos en este primer momento, hemos tenido una respuesta judicial relativamente ágil. Bueno, y además de todo eso, ¿qué hemos dicho los jueces españoles en los últimos meses? Pues que nos gusta la aplicación privada del derecho de la competencia y que queremos resolver casos en materia de aplicación privada del derecho de la competencia. Los jueces españoles ya han afirmado su jurisdicción comunitaria, su jurisdicción internacional, para el conocimiento de las acciones entabladas en España contra cartelistas con sede social, con implantación en otros Estados miembros o respecto de conductas colusorias que han sido desarrolladas en otros Estados miembros. No es un trabajo completo. Este primer problema o este primer aspecto de la reafirmación de la jurisdicción española ya evidencia que la jurisdicción española tiene que seguir madurando, tiene que seguir creciendo. ¿Por qué? Pues porque de momento nuestro Tribunal Supremo no ha resuelto o no ha apreciado el carácter comunitario de este tipo de procesos y toma sus decisiones con arreglo a la legislación nacional, a las normas de transposición nacional de la legislación comunitaria. En materia de competencia, el reglamento del año 2012. Ese es un paso que, como intuyo también en la academia y en la jurisprudencia italiana, en el sur de Europa tenemos que dar y darnos cuenta de que son procesos en aplicación de derecho comunitario con el efecto directo de los artículos 101 y 102, huyendo de la traslación nacional que hemos hecho en España, en Italia también, de estas normas nacionales, de estas normas comunitarias. Bueno, ¿cuáles son nuestro bagaje, nuestras maletas para resolver estos procesos? Tenemos una gran ventaja a la hora de identificar nuestros leading cases, porque tenemos uno. Es así. En el año 2013 el Tribunal Supremo Español resolvió una acción muy importante, follow-on, en materia del cártel del azúcar. Bien, ese es el pronunciamiento más reciente, ha habido otros pronunciamientos, pero el paradigmático es este, el pronunciamiento más reciente y que establece las bases en el año 2013, anterior a la directiva, y que permiten intuir cómo se van a comportar los jueces. La primera conclusión que uno puede sacar, crítica a la lentitud, en el cártel del azúcar fue una sanción administrativa en el año 1900, una sanción de la autoridad en el año 1999, confirmada por la jurisdicción contenciosa. Esa gente, yo soy mercantil, público-privado, no sabemos mucho los unos de los otros, en el año 2006. Y luego empiezan los procesos follow-on. Es demasiado tiempo. Si el derecho de la competencia, la aplicación privada, tiene que cumplir una finalidad disuasoria, nos tenemos que comprometer todos a responder de una manera más rápida. ¿Cómo? Pues haciendo las cosas más sencillas, más simples. Bueno, además de esta crítica a la construcción procesal o al tratamiento procesal, ¿qué es lo que dijo el Tribunal Supremo? Uno, que todo el mundo tiene derecho, todo perjudicado tiene derecho a que le resarzan. ¿Eso es algo que tenga que ver con la aplicación privada del derecho a la competencia? Sí, pero ¿es un patrimonio del derecho a la competencia? No, es un principio general del derecho civil y está en cualquier texto europeo sobre Torlau. Además de todo eso, otro tipo de conclusiones. Respondió con arreglo a categorías nacionales de responsabilidad extracontractual. Algunas de las preguntas que usted planteaba en la tarde de ayer parten del mismo razonamiento y del mismo análisis que hacen los jueces españoles, con reglas de responsabilidad extracontractual, identificando acción, culpabilidad, daño. Admitió la vinculación a lo resuelto por la autoridad de competencia. Tradujo al ámbito del derecho de la competencia la regla ex re ipsa, y además de todo eso, pues estableció cargas probatorias en materia de Passinon. Pero la lección aprendida para los jóvenes, como muchos de vosotros que estáis aquí estudiando, ragazzi, no nos tiene que dar miedo el derecho de la competencia. En apariencia puede parecer muy complejo, porque lo es técnico, es sofisticado, pero reafirmándonos en nuestros principios de derecho civil es una buena base para enfrentarnos con estos problemas. Además de todo eso, en los últimos años, pues el follow-on o las acciones follow-on parece que han llegado a España para quedarse. 2 años después empieza en primera instancia el siguiente caso paradigmático, cártel de los sobres de papel, donde pues, tuve una participación personal en los juzgados mercantiles de Barcelona. Mismas demandas, mismas periciales, jueces procedentes de un mismo circuito de formación, jueces de la misma edad, más o menos. Barcelona acepta las demandas, Madrid las desestima. ¿Cuál es la diferencia? Pues yo creo que la diferencia en estos casos es la visión de cómo tiene que conducirse un juez. Y eso está en discusión en España. ¿Qué modelo de juez? Un juez viejo que responde con arreglo a normas y a categorías procesales de su propio derecho nacional buscando una seguridad, o un juez más progresista que intenta buscar una interpretación autónoma de las reglas del derecho de la competencia. Segunda lección española para los ragazzi de Trento. Partimos del derecho civil, pero además de eso nos tenemos que atrever a buscar un sentido nuevo a esas reglas civiles. Buscar cuál es su significado y su correspondencia con las categorías propias del derecho de la competencia. Algunas opiniones personales respecto de cuestiones que están en discusión en el cártel de camiones y que tienen que ver con el trabajo que se ha hecho en España durante los últimos 4 meses. En España ya hemos hecho un esfuerzo para distribuir las cargas probatorias, para explicar quién tiene que hacer qué en cada proceso. Qué es lo que tiene que probar el demandante y qué es lo que tiene que probar el demandado. También en relación con la Passinon. Bien, lo que nos falta es darle contenido a esas reglas abstractas, teóricas, en casos concretos. Y ahora en España nos enfrentamos a la aplicación del Passinon en un caso donde lo que se discute no es si el destinatario final de un producto lo ha trasladado a otro a través de su proceso industrial, en una cadena de suministro. No, porque es el destinatario final. Ayer la magistrada de Milán describía el Passinon identificando el destinatario final, estaba en una de sus slides. Bien, la cuestión ¿es admisible o no es admisible la defensa del Passinon no cuando hay una traslación del mismo producto, sino cuando eso determina tu política de precios respecto de tus clientes que operan en un mercado distinto, próximo o no, a aquel en el que tú has sufrido la práctica cartelista? Muchas frases subordinadas, no sé si esto se habrá entendido bien. Scusi. Bien, pues siguiente lección del derecho de la competencia. La economía es un lenguaje. La economía sirve para explicar con magnitudes autónomas factores, hechos que no son economía. Nuestro trabajo como jueces, nuestro trabajo como juristas es eminentemente jurídico y buscar soluciones jurídicas a problemas que son jurídicos. En el ámbito del derecho de la competencia no podemos menospreciar, y es la gran riqueza de la jurisprudencia y de la jurisdicción inglesa, es evidente, la visión económica, lo que significa para la economía esas categorías legales. Pero no podemos dejar que la economía, porque solo es un lenguaje, que la economía lo invada todo. Nuestro trabajo es legal. Volvemos a lo mismo. Entonces, lo primero, ¿qué es lo que tenemos que hacer? Buscar en nuestro bagaje de derecho civil. Bueno, pues ahí cobra valor preguntarse o reproducir este esquema de defensa del pasinón con arreglo a principios civiles generales, donde hay un vínculo causal que permita una comunicación de daños y donde no lo hay. En esto, en España, estamos discutiendo. Hay una posición minoritaria, muy minoritaria, es la mía, que defiende la irrelevancia en un proceso follow-on de aportaciones económicas más allá del vínculo causal del mercado afectado por la práctica anticompetitiva de que se trate. Bueno, en el futuro, el Tribunal Supremo, nuestro Tribunal Supremo, que ya ha establecido unas reglas en su leading case sobre carga probatoria, tendrá que examinar por primera vez el pasinón en casos concretos y tendrá que adoptar una de las dos posturas. Esperemos que acierte. Además de todo esto, los jueces españoles ya hemos tenido la oportunidad de preguntarnos sobre la responsabilidad de las filiales. Y tiene que ver, por supuesto, con una buena parte de los argumentos que se han dado en la mesa anterior. Nuevamente, en un pronunciamiento aislado y minoritario, la jurisdicción española ha aceptado la legitimación pasiva de las filiales españolas de una matriz condenada por prácticas anticompetitivas. Más allá del caso concreto hay que hacerse preguntas generales. ¿Quién tiene que responder del daño? Eso es una pregunta civil general. La respuesta es civil general, quien lo haya causado. ¿Y quién lo ha causado en el ejercicio de una acción follow-on en relación con una infracción? Pues ahora sí, haciendo ese esfuerzo que tenemos que hacer para ir del derecho civil, nuestra base, a las categorías particulares del derecho de la competencia, pues tendremos que entender en esa aplicación nueva y como operadores jurídicos nuevos que hay una disolución, una dilución, una liquidación de categorías de imputabilidad tradicionales, y que la construcción, nuestra sólida construcción de la personalidad jurídica de los patrimonios separados, eso en derecho de la competencia no sirve. Y tenemos que preguntarnos quién ha generado qué distorsión en el mercado y de qué instrumentos se ha servido para distorsionar el mercado y para convertir un mercado perfecto en uno imperfecto. ¿Cómo lo ha hecho? ¿A través de qué instrumentos se ha servido? Eso es un agente económico que opera en el mercado. La imputación en el ámbito de las acciones follow-on tiene que superar los criterios de personalidad jurídica y tratar de explicar cómo ha arraigado económicamente en el mercado la conducta de que se trate. Y, hombre, en el contexto de grupos absolutamente cerrados, donde hay una relación instrumental de la matriz hasta su implantación en cada estado, yo creo que tenemos que ampliar la capacidad de enjuiciamiento y de imputación. Otra cosa es, y esto también es otro plano de la discusión en España, si eso se tiene que hacer a través del ejercicio de una acción follow-on o es necesario el ejercicio simultáneo de una acción stand-alone respecto de los que no son destinatarios de la decisión. Bueno, es un matiz pues, muy importante, pero en fin, yo creo que ya respondiendo a través de los hechos concretos de la infracción de que se trate, si la infracción permite reconstruir vínculos de imputación, entonces no será necesario el ejercicio de una acción stand-alone. Evidentemente, nunca habrá un automatismo entre una resolución que sanciona y el ejercicio de una acción follow-on frente a alguien que no sea destinatario. Hay que dar una justificación añadida para imputar, pero no debemos tener miedo a hacerlo en el contexto de una acción follow-on. Bueno, tenía que hablar, de acuerdo con la lista de issues, sobre el disclosure. Mi opinión sobre el disclosure y la traducción que hemos hecho en España. Bueno, Cuando un proceso de acceso a fuentes de prueba, que es como se llama en España, se judicializa absolutamente, entonces eso no es un disclosure. El acceso a esos medios probatorios tendría que ser extrajudicial. La fiscalización y la intervención y el impulso del juez desnaturaliza ese mecanismo y lo hace muy parecido a soluciones procesales civiles que ya existían, a buen seguro, en el ordenamiento procesal civil italiano y también en el español. Es cierto que la traducción de la directiva a nuestro sistema ha permitido actualizar estos mecanismos que ya existían, darles más contenido, hacerlos más modernos, adaptarlos, construirlos de manera paralela a la transposición de la directiva en materia de secreto. Es muy positivo, pero la funcionalidad del mecanismo es muy incierta. En primer lugar, por su complejidad, y por complejidad entiendo por su judicialización, y además de todo esto, también por la ausencia de mecanismos de coerción frente al solicitado. La traducción que se ha hecho en España de la regla de coerción en el disclosure es la posibilidad de que se tengan por admitidos determinados hechos. Pero eso es diabólico para el actor. ¿Por qué? Porque el actor que recurre al disclosure, cuando recurre a él, el futuro demandante, reconoce su incapacidad para articular una demanda. Necesita fuentes de prueba de las que carece. Si carece de fuentes de prueba, ¿cómo va a imputar hechos y consecuencias jurídicas concretas con las que amenazar al demandado para que coopere con el disclosure? No parece que tenga mucho sentido. En fin, bueno, también en España sobre el disclosure nos hemos planteado a propósito de qué opción, qué papel van a jugar las filiales de market subsidiaries en esto. Si pueden tener responsabilidad es algo dudoso, es algo que tendrá que solucionar el TJUE, ni siquiera nuestro Tribunal Supremo, pero creo que en acceso a fuentes de prueba hay un gran consenso para exigir a las filiales que colaboren en el esclarecimiento de algunos hechos. Hay una relación de inmediación. Un proceso de disclosure que está planteado frente a una matriz extranjera no será eficiente, cuando las medidas del disclosure más severas son el acceso a las oficinas, los registros, la incautación de documentos. ¿Cómo va a hacerse eso frente a una matriz extranjera? Bueno, alguna más cuestión más muy breve respecto de la cuantificación de daños, y con esto he fermato o sé finito. Los jueces tenemos trabajo nuevo. Tenemos un papel que va mucho más allá de cómo hemos entendido la posición del juez civil en el ámbito latino. Fuera del principio dispositivo, fuera de las reglas de congruencia, sin que eso signifique mermar nuestra imparcialidad. Tenemos un mandato nuevo y es estimar daños en supuestos de dificultad. Y los jueces tenemos que acostumbrarnos a recurrir a este tipo de a este mecanismo en situaciones de insuficiencia probatoria. ¿Por qué? Pues porque serán las normales. Nuestro Tribunal Supremo, en aplicación también de la doctrina europea, ya ha establecido, ha clarificado cuáles son las reglas de carga probatoria. Al actor le basta con formular una hipótesis razonable de cuantificación de los daños. Y el demandante tiene que realizar una cuantificación alternativa. Pero el hecho de que el Tribunal Supremo haya clarificado esos roles no quiere decir que en la práctica de los nuevos casos la situación vaya a ser fácil. El escenario habitual seguramente sea un callejón sin salida, en la que el juez va a tener que hacer uso de sus facultades alternativas para cuantificar daños. ¿Cómo los tiene que hacer? Bueno, pues yo creo que como los jueces tenemos un nuevo trabajo, necesitamos profesionales que nos ayuden. A vosotros, para que nos ayudéis a tener una visión económica nueva, partiendo de esas soluciones civiles, una nueva visión sobre la autonomía y la aplicación directa del 101, 102, etc. Pero además también necesitamos la ayuda de las autoridades de competencia. Si la aplicación privada del derecho de la competencia tiene que cumplir fines de disuasión, de ahora en adelante las autoridades de competencia tendrán que escribir para ser leídas, no solamente por jueces contenciosos, jueces administrativos, que confirmarán o no sus multas, sino también por jueces civiles que las vamos a aplicar. Necesitamos que en sus resoluciones la Comisión, las autoridades nacionales, nos den algún vestigio, algún parámetro para realizar nosotros esa labor de estimación. Y además de todo eso, necesitamos que el amicus curiae sea un amicus di verità y que nos ayude. No sabemos muy bien qué es lo que se puede esperar de esa relación con las autoridades de competencia. Los jueces españoles, los jueces especializados españoles, hemos recibido con claridad los inputs de las autoridades de la competencia. Tenemos que proteger al clemente, leniency, ¿no? The leniency programs. Tenemos que proteger. Además de todo eso, no podemos trasladar nuestro trabajo de cuantificación de daños a las autoridades de la competencia. Sabemos muy bien qué es lo que no podemos hacer, pero yo todavía no sé en qué me puede ayudar a mí la autoridad nacional. Bueno, pues, en fin, creo que en el año 2021 hay una parte del programa, ¿no?, ya hecho, pues esto tiene que estar en el 2021. En fin, yo concluyo ya. Muchísimas gracias por la atención. Lamento mucho no haberme podido expresar en italiano ni en inglés. He disfrutado estos días aquí junto a vosotros y hasta pronto.
Muchísimas gracias, Eduardo, por estas lecciones españolas sobre el derecho a la competencia y la aplicación privada. Es muy, muy interesante lo que has comentado. Yo creo que es inspiring, ¿no?, también para nosotros. Yo creo que además el ordenamiento español ha hecho unos pasos hacia adelante muy interesantes. Nos tenemos que acordar que vosotros habéis empezado con un plazo de prescripción muy breve en estos temas, ¿no?, con, creo recordar, 1 año para la extracontractual. Esto obviamente es un tema muy, muy sensible y de lo que hemos hablado ya. También creo recordar que antes de ir a un juzgado, antes se tenía que esperar una decisión firme de la autoridad de competencia. ¿Solo stand-alone cases o no? Si nos puedes contar un poco esto.
En primer lugar, en España es cierto que el plazo es de 1 año, o era de 1 año, tradicionalmente, excepto en Cataluña, que eran 3, es un momento difícil. Pero no es un plazo de caducidad. Es un plazo que se puede interrumpir indefinidamente con un límite, que es el retraso desleal en el ejercicio de las acciones. Entonces, la prescripción no es un problema en España. No lo ha sido hasta ahora, si el futuro demandante ha sido diligente en la conservación de su derecho. Y en segundo lugar, sí, evidentemente, es cierto, respecto de la segunda pregunta, que en la naturaleza y en la esencia de una acción follow-on, pues está el esperarse a la firmeza de la resolución administrativa. Sin embargo, en España hemos tenido casos confusos quizás en su tramitación, porque estábamos aprendiendo y madurando, recientes, de tramitación paralela, de acciones de stand-alone y follow-on, mientras la resolución administrativa no es firme. Bueno, quizás pues no hemos entendido bien, o en esos casos en los que yo tuve intervención personal, no entendimos bien el mecanismo de relación con el proceso administrativo, pero en cualquier caso es ya una base suficiente para enfocar el futuro con más seguridad.
Muchísimas gracias. Let's switch again to English. So it's now time to speak about Germany. So Franziska Weber from Hamburg University. The floor is yours. Please, go ahead.
Yeah, thank you very much for having me. I shall indeed tell you a little bit about those points from a German perspective. To start with, our enforcement landscape is like, I think, in most European countries, or all of them, shaped by an interplay of public and private enforcement. So there has been a large, long tradition of public enforcement by the Bundeskartellamt, and increasingly now we see the interaction or the also individual actions in private enforcement. We have no such thing as a specialized court for competition cases. I also wouldn't know of any immediate plans to install such a court, but we do in the general courts have specialized chambers or senates for competition cases. To give you a good overview of our landscape, since last year we have something which, from our perspective, comes closest to collective redress mechanism that we have ever had. I don't think you can really call it a fully fledged collective redress mechanism, because it still is a two-step procedure in the sense that you cannot obtain damages or compensation immediately, right? It's more of a declaratory judgment, and then there can be follow-on litigation, which was facilitated because certain aspects have then already been clarified. Having said that, there is an alternative option within that system to come to a settlement on the basis of these declarations, and so possibly we'll see how the usage of this instrument is going to develop. That could be a way to come to an assessment of the individual damages per person within the context of that settlement agreement, which is then approved by the judge. And there are many more procedural aspects to it. I don't want to go into too much detail, but it is only applicable for consumers, and it needs to be a representative action. So it could be, from the final consumer's point of view, theoretically be also applicable to competition cases. Many doubt the effectiveness if you read through the first comments on this act from a competition perspective, mainly because it doesn't immediately give you compensation, and then there may be other problems of small and widespread damage and so forth. In general, we do see an increasing number of cases and court judgments. However, the number of judgments we see doesn't really reflect what's going on, because there are lots of settlements that are not made public. Of some you may have some knowledge because there was originally a case started, but of others you may not even. When it comes to cases, we have had 4 cases that made it all the way up to the highest court, the Bundesgerichtshof. And they will come back throughout my presentation, so let me just briefly mention them once. So there's on the one hand a price cartel case regarding carbonless paper. We had another issue with lottery companies that also made it up to the Supreme Court. There's a recent decision on a cement cartel case, and there was also a railway cartel case. Sorry, it's a bit far away, so I'm always estimating if my slide is following me the way I hope. Right, so these are the 4 cases, and throughout now going through some of the elements that we wanted to look at, they will keep coming back. I found one graph or slide that could possibly exemplify a little bit what has happened in Germany in terms of numbers increasing when it comes to private enforcement of competition law. Right? We see a little bit has happened in the years of 2003 to 2005, and then really in the last years we see a steady rise. That's the yellow part that's the railway cartel follow-on litigation, for instance. But this goes until 2017, and we can add that over the course of 2018-19, around about 10 cases, for instance, this is only first instance courts, by the way, also for the truck cartel have already been passed. And according to estimations, there are really various hundreds of cases pending. They concern mainly the truck cartel, but also a sugar cartel that was detected. So those numbers, well, are really just maybe the tip of the iceberg, and it's only the judgments. But it shows you the general trend, which is generally true. Right. Coming to some insights, maybe, from those cases from the truck cartel so far, that litigation hasn't reached the highest court, but we have first and second instance cases. I would say the outcome is overall claimant-friendly so far, in the sense that the prima facie evidence of the existence of an overcharge, well, is accepted by the courts, and makes life for the claimants a bit easier. That was a German tradition already in previous case law, and is at the moment here pursued. I'm going to say a little bit more about that in a moment. And we also see overall a very restrictive approach regarding the admittance of a pass-on defense. Right? You have talked a little bit about also the question, can we still grant pass-on when we actually don't see how the claimant has sold on the good to a next market, really? There are various reasonings as to there's no such thing as a downstream market if it's about, for instance, one is a public waste collector, right? So there's not really competitors when they have to provide their services. Or what about, there's something about firemen. There's also the question of leasing out the trucks, or in one case, the trucks were only sold on after having been used for many years, really late, as a second-hand good, right? And also there it was argued that, well, in that price then of that second-hand good, you can't really see the pass-on of the overcharge anymore. So really there was a rather restrictive approach here so far, which could be interesting also for you maybe to look into in more detail. One second instance court judgment, the full text is not available yet, has also, for instance, confirmed this claim on the existence of the damage as such. Here I can already mention maybe that this is really deeply ingrained in the German system, that we have rarely any decision on the amount of damage yet. It normally stops at the level of confirming the existence of the damage, and then, well, the damage should be calculated in a later stage. I will also come back to this strategy or procedural element a little bit more, right? So the second instance court judgment also does just that, confirm, though in the interest of the claimant, that there is such thing as a damage, and it also rather forthcomingly or easily accepts the existence of an overcharge, for instance, referring to documents such as the Commission's decision, and also referring to a latest reasoning done by our highest court, which, could possibly change some things, but maybe also not. I'm going to say something more about this on this next slide, which is about standing and pass on, because the overcharge is, of course, the precondition in a way to ever come to pass on at all. And the railway case, right, that's our railway picture, is interesting in the sense that the judges didn't that readily accept that there was prima facie evidence for an overcharge. In the end, they don't accept that, but because it was not, damage is not the typical consequence of a cartel. Well, that is the reasoning. But they do still grant what is maybe loosely translated a de facto presumption, right? So still we are debating in our literature now how much would now really change. I mean, it seems to be a little bit less claimant friendly, but the extent, and now I come back to the previous slide in a way, so the second instance courts did use this new reasoning, but still came to the conclusion that there was such thing as an overcharge, right? So in the end, the result here didn't change. And what we also see is that some courts are now currently going against that decision in a way, still, even after the highest court has said there's no such thing as prima facie evidence, still go along the lines of that reasoning. So we'll see about that. But clearly, when we look at the directive, right, there is the presumption. So what's going to come is a presumption for future cases. So it is interesting to see, in how far we can here look at economic realities in a way different before and after the transposition of the directive. So it's an interesting judgment. To pass on more specifically, in the German cases, in the Orvi case on the carbonless paper, the necessities for pass-on were clarified in 2011. And one interesting aspect, which actually also your sugar cartel case touches upon, is the question, right, so it is the defendant that has to prove the pass-on, but what about the possibility of another damage component, right, the volume effect? Because if you had to increase your own prices as a purchaser, that would normally mean that you also sold less of your goods, right? Some consumers wouldn't be willing to pay such a high price now for that product and would not buy your product anymore. So typically you can have a loss of profit because of this reduction in demand. And in the German judgment, we actually required the defendant to consider this, to show that when alleging the pass-on defense, they had to show that there was no such thing as a volume effect for the claimant. So he didn't have that type of losses, and only then, in essence, could they bring the pass-on defense. And there's lots of writing on whether this is still compatible with the directive, because of the directive, I would say on a first look, clearly says the claimant has to prove possible volume effects. In the beginning, people were very much of the opinion that it is incompatible with the directive, what we had in our case law, but increasingly, I would say now it's almost 50-50, people become more generous in the sense that also under the directive, you could argue why we could facilitate the burden of proof for the claimant, possibly even in such a way that we, in the end, impose it upon the defendant. But that's a bit open to debate. So that's one of our pass-on issues. I'm really investigating this volume effect in depth. So if any of you has interesting insights, please do contact me. I'm very curious. Right, okay. Another argument I mentioned on the pass-on that's interesting is these no market, if you wish, arguments. There couldn't have been any pass-on, so that's mainly with the drug cartel. Another a discussion about pass-on is the question, right, so if we don't grant the pass-on defense because we argue that, well, the next level then wouldn't be suing because, for instance, damage is very widespread and they don't have any incentive to sue. This currently, for instance, the court in Dortmund uses this reasoning, as a value judgment can be made, but I wonder if under the directive, which grants, I think, the defendant the right to allege the pass-on defense, such a value judgment could still be made or not. And I know in other jurisdictions it's currently also being made. So I think that's interesting to see. Regarding purchaser standing, just very quickly, we have clarified once more, let's say, with our carbonless paper cartel case, and also whereas literature was divided on the umbrella effect before Cone, now clearly they would also have standing in German law. With a view to disclosure, beyond doubt, the directive expands the scope for such rules in the German system, but it really depends very much on the willingness of our judges in how far this is now in practice going to change things. Yeah, the general approach in Germany is here rather restrictive, like the civil law countries or those traditions in general. One thing to note about how we implemented the disclosure rules is that we make a differentiation between claimant and defendant in the sense that the defendant can only make requests once the case is pending, but the claimant can already make it up front. We have now not really seen, or I can't tell you much about how we apply disclosure, because we have a little problem now with the temporal application. I think someone earlier said so it's a procedural matter. Yeah, in the directive it's a procedural matter, but in the German tradition we have implemented it as our classic mixture of needing a substantive claim and then the procedural law, to execute this in a way. And this tradition we have also followed when implementing now the directive. It was the intention of the legislator still that those procedural rules would be available from the moment that the implementation period of the directive ended. However, our court in Düsseldorf, the second instance court, interprets our new act a bit differently, or very differently, in the sense that they say, well, actually, these disclosure rules become only available for claims that rise after the implementation period, 26th of December 2016, I think, has ended, right? So not for any cases lodged after that. And so a little bit... maybe you know more, you have a huge and bigger network than me, but currently we're a bit stuck here. It's unclear how we could overcome now this interpretation of the Düsseldorf court quickly, even though it seems to go against the legislators and clearly the Commission's view. Right. Okay. On quantification of damages, I also want to mention some points. One judgment here, that's the lottery company judgment, is interesting. It's also from a dogmatic point of view, maybe very interesting, but it makes clear that the scope of the court's powers to estimate damage really concerns both existence as such, right, and the actual amount. That has been before. There are different opinions about that, not about the estimating the amount, but about whether it applies also to the existence. Of course, the directive with its presumptions will prevail for many aspects, but here comes, for instance, my dear volume effect, right? So the directive, I don't think, says anything about a presumption for a volume effect, so here it would still be relevant that the estimation can be done for both existence and amount. So there might be categories of damage where this could still be relevant even after the implementation. We have, as a little trick, maybe, I don't know, helpful element, such a thing as liquidated damages clauses. For instance, in one case, before a court in Hanover, it was 50%, right? In case it turns out that there was a cartel, then we would assume that the overcharge was 15%. That was spelled out in the general standard contract terms. And the courts so far have approved of this practice if it is, however, still possible to also go below or above. So we are really reluctant to quantify, right?
That's easy.
Yeah. So there is one case here in the early one, in the vitamin case, where actually an overcharge of 33.5% average was awarded, but that's really exceptional. In the someone studied this, so I didn't have to do this. So here it looks as if there were actually more cases where we did put a number, but you have to look at them, I think, with a grain of salt, because the judges never really did it on their own, right? There was either a liquidated damages clause in the sense that you could, well, get the percentage from there maybe, or they had good information from the commission documents, for instance, or the decisions. Yeah, so this was published first, and then someone else said, yeah, but if you look at the numbers carefully, I think it's not really a sign that we have here good estimation powers, but it is really, when we have lots of help, then we might put a number. Yeah, so there's really generally a major reluctance. What we see is declaratory judgments, and that can be either that the claimant only asks for that and says, okay, and then the amount, well, later, or it can be done within the procedure, even if the claimant actually puts a number and wants to have compensation for that amount. The judge could still decide that within that procedure it's not possible for him or her to assess the amount and transfer that, let's say, to a next proceeding. So make it a two-step procedure. That is really the trend, and if you talk to classical procedural lawyers, sometimes they are shocked because they say, okay, but isn't there a subsidiarity idea, right? You should only go for the declaratory judgment situation if the other type of claim is not possible. We tended to be, in competition law here, I would say, a bit lenient. It was in essence sufficient to say that no amount could be put because one first had to await the expert report, and that takes some time, which is why, to avoid prescription, we bring this other type of claim. Yeah, this was an issue then in our latest cases in 2018, cement and railways, and there was explicitly stated that waiting for the expert report now is not sufficient a reason anymore to only go for declaratory judgment. However, in the cases at hand, it's not an issue because there is some uncertainty in our law regarding the prescription period, which is why those cases may still go along that road, and probably cases can still for a long time. And if you talk to lawyers, they say, oh, and we'll find other uncertainties, and we'll still go for this type of claim, because of course it involves, well, much less resources and so forth, and you can still hope for a settlement then or the like, right? So there is development here, and I think my last point is just that indeed I think this discussion on whether it is now typical that a cartel leads to damage and so forth shows, yeah, very much this necessity of the interplay between lawyers and economists, but also the problems that there are with it, in how far we can fit those economic reasonings on certainty, causality, within the legal framework of also causality, right? So it shows this here. Okay, thank you very much.
Thank you very much, Francisca, also because you used just 2 extra minutes, so you are the more virtuous among all of us. Since we are again running out of time, I think it's time to go directly to give the floor to Till Schreiber, who is the managing director of CDC. He will talk about Netherlands. Netherlands, as you know, it's one of the most attractive jurisdictions in continental Europe for competition litigation. So Till will explain us briefly and deeply why. Please.
Yeah, thank you. Thank you very much. Thank you, first of all, for having me here. I will keep it brief and start directly on the situation in the Netherlands. As Michele said, the Netherlands are a very attractive forum, and why is that the case? First of all, there are many cases which have been brought in the Netherlands. They relate to gas-insulated switchgear, bitumen, air cargo, sodium chloride, paraffin wax, elevators and escalators, pre-stressing steel and, in the meantime, trucks. And in these cases, judgments were rendered. And rendering judgments gives legal certainty, which in a way attracts, again, claims or actions, because as a claimant, you are looking for legal certainty in a very complex action. What are the other reasons why the Netherlands are an attractive forum? And I would say for claimants, but also for defendants. First of all, the judiciary is reliable, the system is reliable and efficient. It has recently been ranked the highest in the World Justice Forum survey. The judges are typically specialized. You don't have specialized courts, but you have specialized judges. And the Netherlands being a rather small country, these judges travel to the courts where private damage actions are brought. So you can have a judge, which is normally at the court in Amsterdam, being part of a panel of judges in Groningen or in the south or in Maastricht. And that is interesting because like that you ensure that the judges that deal with cases are experienced in this field. These judges have also formed a small group of specialized judges, and they follow, for example, specific trainings in economics. So they have workshops with professors that tell them about how economics are applied in the context of damage quantification, for example. The Netherlands are also, being a rather small country, they are used to deal with pan-European legal issues. They're used to private international law aspects, which of course in pan-European cartel infringements are relevant. They are typically quite proactive. They take the case management serious, which means you have, similar to the UK, sessions where all parties discuss what are the issues that should be dealt with first and second and third. Documents can be provided in electronic form, so you don't have to file hundreds and thousands of invoices, for example, in order to substantiate the damage in paper form, which may be different in other countries, such as Germany, for example, where in our first case that we brought, the German cement cartel case, we filed a truckload of 10 tons of paper to the Düsseldorf court. They had to put in, or they had to empty a room specifically for the files, and I think never ever somebody had a look at these invoices, of course, but it was necessary to substantiate the claim. What is interesting as well, that in the Netherlands or the Dutch courts accept English language documents. That's, for example, very relevant in the case of economic expert opinions, because good economic expert opinions are a rare good, and so it is important that you have, all the parties have access to these experts, and many of them are only able to express themselves in English and not necessarily in Dutch. Typically, the actions, the damage actions relating to antitrust infringements are brought in a two-step procedure. First, the court decides on the merits, i.e. is there a liability, and then goes into the question of quantification. Often the question of quantification is somehow left then to a settlement between the parties. Mm-hmm. But many times the questions of liability are discussed in very much detail. The courts use interim judgments, so it is very normal that, for example, judges first decide on questions such as competence of the court. Secondly, the applicable law. And thirdly, things such as are limitation periods applicable, and if yes, is the claim time-barred or not, before going on in the procedure. Another very important aspect for all parties, I think, are the very clear and accessible cost rules. That refers to the cost rules regarding court fees, but also adverse cost rules, i.e. potential cost risks that you face when you lose a case. And there are, of course, very significant differences in the jurisdictions. I think one of the main differences to the UK is that these fees are significantly lower. For example, bringing a case to a court in the Netherlands in the trucks case costs, I think, 600 euros court fees. So in Germany, the same would be at least 235,000 in the first instance, and if you go 3 instances, it would be close to €1 million. So that's an important aspect. I briefly want to talk about 2 future developments, I would say, or very current developments, which could lead to a situation that the Netherlands is becoming even more attractive. First of all, the Netherlands introduced the so-called Netherlands Commercial Court. It is competent to hear commercial actions, including competition damage cases. It is conditional upon all parties consenting to the competence of this court, but then the proceedings will be conducted in English entirely. They are subject to the procedural law of the Netherlands, but the pleadings and proceedings will take place in English. And also the judges will be speaking and hearing in English. The judges that are appointed to this specialized court are all very experienced and senior. They also apply a paperless proceeding, so everything is filed in electronic form. And in order to provide all these services, they allow for a higher court fee, but it's still comparably accessible for all parties. We're talking here about 15,000 to 20,000 euros per party. Another development in the Netherlands is the introduction of a collective action, a new collective action regime. There is one in place. It will probably enter into force relatively shortly. However, it will only apply to situations, I think, after October 2016. That's when this action or collective action process started. So it will not be applicable to cases prior to 2016, which means that it probably will not apply to many of the cartels which are currently either in the public domain or still being investigated by the European Commission or the national competition authorities. It is an opt-in, it is opt-out for Dutch victims. So all Dutch victims are comprised, but there's also a combination that victims from outside the Netherlands can opt in. So it could theoretically be attractive even for victims with a location outside the Netherlands. Contrary to the current situation, the claimant, which is typically a claims organization, which has to fulfill specific requirements regarding the know-how, the funding, the experience, transparency, they can ask with the new system for monetary compensation. Currently, they can only ask for stopping the infringement. This system is combined with a so-called collective settlement mechanism, which is already in place right now, and which allows for opt-out settlements, potentially with a pan-European reach or even a global reach. It's done typically in the context of class actions in the field of financial products when parties want to reach a final settlement and they apply it on a global level. I mean, it's questionable whether that will be accepted, but it's nevertheless a solution to bring a specific litigation to an end. I'll now discuss two cases, and in the context of these cases I will talk about things like quantification and touch a bit on disclosure as well. So what are the lead cases? I think the clear lead case in the Netherlands is Tenet versus ABB. It's a follow-on action which has been brought in the Netherlands in the context of the gas-insulated switchgear cartel. In the case, the Dutch grid operator sued the Dutch subsidiary of ABB and also the parent company of ABB, which is based in Switzerland. The applicable law in this case was Dutch law, because the contracts were subject to Dutch law, and the purchase of the gas-insulated switchgear took place in the Netherlands. And the case is very interesting because it went all the way to the Supreme Court, in particular regarding the principles of law, so the merits of the case. And the Dutch Supreme Court first of all confirmed that there is a right to claim damages based on EU law, however governed by national law. It confirmed the joint and several liability of cartel members. It also confirmed that the concept of a single and continuous infringement is applicable in the private enforcement context. And it confirmed that indirect purchasers have a standing and that the pass-on defense is available. So a lot of fundamental questions regarding the merits. But then, of course, the interesting part is how is it applied in practice regarding the quantification. And that's quite interesting to see how the first instance court and the second instance court are dealing with the question of how to quantify, first of all, a damage, and secondly, how to apply the passing on defense. The first instance court awarded a substantial damage. It's the first time that a substantial damage was awarded in the Netherlands in a private antitrust case. They awarded 23 million plus statutory interest. In the case, the claimant had produced an economic expert opinion which quantified the damage exactly in this 23 million based on a during and after approach, i.e. comparing the prices for a specific product during the cartel and after the cartel. There was a price difference of 54%, and the court was convinced and followed the economic expert opinion of the claimant that this was basically the result of the cartel. The defendants had produced even two expert opinions, mainly based as well on a during and after comparison, but also providing a lot of internal cost and margin data, and came to the conclusion, no, there is no overcharge. The first instance court did not follow this, so it turned to the question of passing on. Here the court took the judgment of the Supreme Court, which had granted the right to invoke the passing on defense, but the Supreme Court had also made clear that the question of pass on is in the end a legal question regarding causality, and also a question of reasonableness. And therefore, the Court of First Instance, in this case, decided it is not, or it was not reasonable, there was no reasonable link to the cartel because it was not clear whether everything had been passed on. And even if that was the case, the pass on should not be granted because the end consumers, which are then the customers of the electricity companies, did not bring an action, and if they wanted to bring an action, it would have been time barred. So, but the reasoning was, okay, the cartel member should not keep any illegal profit. This judgment is now under appeal, and the Court of Appeal has decided to appoint an economic expert, a court-appointed economic expert. There's actually 3 experts for the question of the damages, but also for the pass-on. So they want to know apparently more about the facts before taking a decision on whether or not to apply legal standards such as reasonableness or causality. So an interesting approach. And what is interesting in how the court, in the judgment appointing the economic experts, the court identified, let's say, common approaches between the various economists. So they found out that all economists agreed that the principle should be a comparison during and after, for example. So they kind of agreed on a specific method. In that context, maybe what's interesting regarding questions such as disclosure, there is a right to disclosure under Dutch law. It's basically dependent on 3 conditions. First, you need a legitimate interest. Secondly, you have to specify the document, so no fishing expeditions. And the document must relate to the legal relationship to which the requesting party is a party. That has been already the case prior to the implementation of the directive. And prior to the directive, there was also a question of whether or not the court has discretion. So the court always had discretion to grant access to documents. However, this discretionary element has been kind of taken away by the implementation of the directive. So nowadays, if these conditions are fulfilled, you have to grant access to the required documents. But there are no cases yet where that happened. Nevertheless, in the gas insulated in the TenneT ABB case, the question came up whether the margin and cost data which had been used by ABB in the context of the economic opinion to justify that there was no overcharge would be accessible also for the claimant and the claimant experts and the court also. And there the court, ABB had requested that there should be a confidentiality ring. However, the court decided that the principle is transparency and openness, and that whatever is discussed in the court should be open to the public, and that in this case it was not justified to grant an exception because the margin and cost data, even if it allowed to identify the business approach of ABB in the past, was more than 10 to 20 years old, so no confidentiality was granted. So we'll see how this further develops. Briefly on the trucks case. The trucks case is kind of very active in the Netherlands. There are many actions, I think, similar to the situation in the UK. Around 8 actions plus other actions will be filed. Out of these actions, 4 are very large actions with a pan-European scope, where so-called claims vehicles, which have gathered claims from other European countries as well, not only the Netherlands, bring claims in one single action. And 4 of those are pending before the court, and the court has decided that everything should be concentrated in Amsterdam. So even claims which were pending in other parts of the Netherlands have all been concentrated in Amsterdam, and the court is now in the process of adjudicating on these matters. And the court has accepted international jurisdiction, so it has accepted that all cartel members can be sued in front of the court in the Netherlands, even if they are not established in the Netherlands, based on Article 8, 1 of the Brussels 1 bis regulation. It has accepted so-called extensions of the claim, so that the more victims can be added in the procedure to the ongoing action. And the court will decide, I think by 1st of May, that's at least what it indicated, on the question of the substantiation of the claim, i.e. Showing that the individual victims have indeed been affected by the cartel. So the question is, what does the claimant have to show in order to substantiate the action or the claim in such way that it is likely that the court decides, or that the company has actually been affected by the cartel. So that's going to be an interesting question, which will probably also be relevant for other cases. I think I'll leave it.
How many slides? And then I tell you the minutes. In 2 minutes more.
Okay. Then I very quickly talk about a case where we have been involved in. It's the follow-on action to the sodium chloride case. It's maybe complementary because it concerns a lot of procedural questions. Basically, it was an action which was brought by CDC, where we bundled claims of 10 affected companies with 27 production sites across the EU. They transferred the damage claims to CDC by way of a so-called claims transfer. The claims were enforced in one single action before the court in Amsterdam. The main question at the time was, can you bring one single action against not only the anchor defendant, which has its seat in the Netherlands, which was AkzoNobel in our case, but also to the other cartel members, which were, for example, Chimera in Finland or Arkema in France? Can they be sued in Amsterdam. And the courts in the first and second instance confirmed that this was possible under Article 8.1 Brussels 1 bis. Due to the joint and several liability, there is a sufficiently close connection. The courts also confirmed that it is possible to sue, or that it's sufficient that the parent company is the anchor defendant, even if a subsidiary was the one which was active in the cartel. So it's a bit in line, I think, with the Skanska judgment and the EU concept of undertaking. And the courts decided as well that arbitration and jurisdiction clauses would not be applicable due to the clandestine nature of the cartel. The courts also confirmed that the assignment model, as we call it on continental Europe, is accepted, and that the applicable law is typically the law where the production took place, i.e. where the purchaser purchased the cartelized good. So this results in a situation where you have multiple applicable laws, and in the Netherlands you have the principle Judex Novit Curia, so it's up to the judge to decide which law is applicable, and in this context typically claimants and defendants provide legal opinions. Yeah. So maybe a last point, limitation periods according to the courts in this Aktie Nobel case should be interpreted in line with the principle of effectiveness. So it's also something that we see again in the recent Sogeco case. So overall, I think there is a certain conversion of the approach courts take in different jurisdictions in Europe with regard to fundamental questions such as quantification, pass on, and international competence of the courts. Thank you.
Thank you very much. Thank you very much. Still, unfortunately, we are perfectly late. We were able also to increase our delay, so this was not usual. So now I think it's time to go to a special session of this day, the award ceremony of the Intesa San Paolo Prize. So if you have any question or comments, please we'll move this to the lunch time and breaks. Adesso parlo in italiano perché è un momento particolare per la nostra Summer School, per il nostro convegno. Come sapete, a giugno di ogni anno organizziamo in collaborazione con l'Autorità Garante della Concorrenza e del Mercato, con l'Autorità spagnola della concorrenza, con l'Autorità lussemburghese, con quella francese, da quest'anno anche con l'Autorità slovena, oltre che con l'Autorità catalana e anche alcuni sponsor privati, una iniziativa che si chiama Summer School on Advanced EU Competition Law and Economics. È una settimana che dedichiamo ai nostri partecipanti interamente in inglese, dedicata appunto ad approfondire tematiche che riguardano il diritto della concorrenza e l'economia della concorrenza. Da un paio d'anni, qui forse I switch to the web page. Da un paio d'anni abbiamo istituito un premio proprio per premiare gli studenti più meritevoli, e questo premio in realtà ce ne sono due. Uno che è gestito direttamente dall'Autorità Garante della Concorrenza e del Mercato. Entrambe le call si sono chiuse, credo che l'autorità è adesso nella fase di selezione del vincitore. Ce n'è un altro invece gestito dall'Osservatorio Antitrust in collaborazione con Intesa San Paolo, Le selezioni sono chiuse questa settimana. Io adesso inviterei a questo punto il professor Gian Antonio Benacchio e la dottoressa Irene De Angelis per iniziare questa brevissima cerimonia in cui comunicheremo ufficialmente il vincitore di questo premio e lo investiremo in senso metaforico.
Sì, ha già detto molto Michele di quello che è ormai, sapete, la nostra Summer School, che è già arrivata al 5º anno, alla 5ª edizione. Moena, come quasi tutti saprete, è un posto magnifico e la scelta per questa cittadina non è casuale, visto che il convegno si fa, che il seminario, la scuola si fa in giugno, insomma è il periodo migliore per attirare lì anche le persone con un po' di fresco, e questi 5 anni si sono rivelati sempre molto utili, persone estremamente in gamba. Quelli che vengono sono ragazzi, studenti li chiamiamo, in realtà sono tutti laureati o dottori di ricerca, persone comunque che hanno già una base ovviamente molto solida di studi giuridici. Quest'anno la selezione si è svolta la selezione per quanto riguarda la borsa messa a disposizione dall'Istituto San Paolo, Banca Intesa San Paolo. Era una selezione fatta in 2 fasi. Nella prima fase si sono esaminate tutte le domande che sono pervenute da un punto di vista di titoli e sono arrivate ben 10 domande da tutta Italia. Questa è un'ottima impressione, perché non è facile, insomma, avere 10 domande di persone che hanno trattato temi inerenti alla concorrenza, all'antitrust. Dopo questa prima selezione sui titoli abbiamo selezionato 4 persone che le abbiamo ascoltate oralmente. Abbiamo fatto un esame, una discussione, una mezz'ora ciascuno durante la settimana scorsa, e da questa selezione è il risultato, abbiamo ritenuto, ci siamo poi trovati, riuniti, abbiamo valutato, e la persona alla quale che abbiamo pensato potesse essere più meritevole, quindi ricoprire questo ruolo di vincitore di questa borsa, è il dottor Riccardo Fadiga. Riccardo Fadiga, che può venire. Si è laureato all'Università Bocconi di Milano, e adesso io lascerei alla dottoressa De Angelis così illustrare le motivazioni che ci hanno indotto a conferire questa borsa.
Buongiorno a tutti. Grazie della parola, grazie dell'opportunità. Lasciatemi solo dire, io avrei ringraziato pubblicamente dopo, però in realtà lo faccio adesso. Ça va sans dire che Intesa San Paolo accorda un'importanza primaria al diritto della concorrenza, e questo è sostanzialmente la ragione per cui ha colto l'occasione ed è felice di sostenere iniziative di grande pregio come questo convegno e la Summer School in Moena. Rispetto alla Summer School si è ritenuto che fosse utile per contribuire su più ampia scala al dibattito su un tema che per noi è di grandissima importanza, selezionare un giovane di talento e supportarlo in qualche modo, permettergli o permetterle di avere un momento ulteriore di approfondimento del proprio percorso educativo attraverso la partecipazione, quindi il contributo di Intesa San Paolo per permettere una partecipazione alla Summer School, alla prossima edizione della Summer School di Moena. Come diceva il professor Benacchio, è stata una piacevolissima sorpresa ricevere svariati curricula, devo dire veramente di alto livello, e questo fa sempre bene, diciamo, quando si vede in che direzione vanno comunque le giovani generazioni di colleghi. Di tutte queste candidature la più meritevole noi abbiamo ritenuto fosse quella del dottor Fadiga, e io sono estremamente contenta di questo. Su quali basi abbiamo svolto queste valutazioni? Sicuramente in base ad un percorso estremamente coerente, che però non si è fatto mancare la view internazionale, fondamentale per noi, Sicuramente gli ottimi risultati raggiunti finora, di cui io mi complimento, l'ho fatto prima e lo faccio ancora, anche perché a nostro avviso sono indicativi anche di una forte motivazione a riuscire bene, a fare bene, e quindi per noi è l'auspicio di poter aiutare una persona giovane e talentuosa a contribuire nell'immediato e nel prossimo futuro in maniera positiva al dibattito, allo studio, all'evoluzione su un tema che è quello che in realtà ci raccoglie qui oggi e che per noi, ripeto, è di importanza primaria. Ancora congratulazioni. Esatto, simbolicamente qui hai un kit di materiale che ti servirà per la Summer School. Noi ci incontreremo anche in quell'occasione, questo è tuo.
Grazie.
E ancora congratulazioni. Prego.
Non vi tedio, volevo solo spendere 2 parole per ringraziare gli organizzatori del premio, Intesa San Paolo, l'avvocato Carpagnano, per questa meravigliosa iniziativa che ovviamente è un grandissimo onore per me, e anche in modo particolare il professor Federico Ghezzi, che mi ha guidato nella realizzazione del lavoro che poi è stato scelto per questo premio, e senza l'aiuto di cui probabilmente non sarebbe stato possibile. Grazie a tutti.
Ok, adesso il meritato pranzo, la meritata pausa pranzo. Ci vediamo più tardi alle 3. Grazie.